Well, welcome back to Uncivil Law. I hope you're having a great day. Joining me today is attorney Mark Bederow to talk about Karen Reed, how the trial is going, our different perceptions of the strength of the relative cases, and all things relating to that. How are you doing, sir?
Okay, how are you? Nice to meet you.
It's nice to meet you as well. Why don't you give our audience a 30-second biography of who you are?
Wow. Okay. So
You
my
could
name's
you could take
Mark.
longer 30 seconds if you want.
No, I don't need to take longer than 30 seconds.
Okay.
So I practice criminal law in New York City. I've been doing that for about 26 years. Started out as a prosecutor for about 6 years in the Manhattan DA's office and have been in private practice since then. And I'm from Massachusetts originally, so my interest was picked in some of this, and I just kind of got sucked into this. I'm involved, as most people know, in a tangential case, and was supposed to be a member of Karen's legal team, but the judge wasn't having it. So here I
Yes.
am, ungagged and willing to discuss.
Yeah, that decision by the judge didn't make any sense to me based on the rules.
Me neither.
Her analysis, well, I'd say analysis that implies there was some. There wasn't. It was conclusory.
A little bit, a lot of
So
it.
a lot of it. Yeah, it's like which is a problem on some other things relating to this. Like for example, when she did the order relating to allowing, I think, the dog bite expert or something like the Doe Bear, and it's just like it was conclusory. It's like oh, this person's qualified. He knows what he's talking about. I'm like, and it was frustrating for me as a lawyer because I'm like, I don't know what the rule set is. And then chat asked me questions like, does this mean that person X can testify as to Y? I'm like, I don't know because she won't tell me what the rules are.
It's interesting that you say that, because one of my critiques, if that's the right word, of the judge in this case for many months now has been there's no consistency, there's no predictability, and if anything, you just like to know, where things are. Like, you want an umpire, the strike zone. It is what it is. There doesn't appear to be any consistency in this case. And I mean, she can rule on an objection and she'll say, ask it differently, and it's as improper as the first one, and I'll allow it. And, there's no rules. It appears, at least. No consistency, no predictability.
Yeah, I mean, the only consistency I've been able to draw at this point is just a general hostility towards the defense as a whole and a lack of hostility towards the prosecution as a whole. I mean, as I'm sure you would agree, like different judges will care about different things, and some of them will be a hard ass and some of them won't be. But as long as it's like sort of even to both sides, it's not that big a deal. Like we can make that work. The
Yeah.
problem in my mind is apparently the prosecution's the golden child and the defense apparently can do no right.
It's frustrating. I mean, I can even remember from my old days, we had a couple of very cranky, cantankerous judges in Manhattan who just seemed to hate everyone and hate life. But you know what? They did it equally.
That's right.
They just
Right.
hated you for
As,
being
lo-
there.
as long as you hate everyone, it's not biased, right?
So, they could make your life miserable. They could be unpleasant to be in front of, but it was an equal opportunity hate, and it wasn't biased. When you're ending up in a courtroom where it does appear to be skewed in one direction, there seems to be outrage at minor things in one
Yep.
direction and just completely ignoring other things that could be very offensive and very unlawful in the other direction. And it's the exact opposite. And it's not a good look, it's getting worse. I mean, we've seen it a lot of times, and really it's just the appearance, as you know, that matters. And when you have a case like this, you already have such a large segment of the public who thinks that this case is rigged, it's biased, the cops are corrupt, the judge is unfair. And when you start seeing rulings which appear to be skewed without the same degree of analysis, I mean, it's just not a good look overall.
No, I mean, I completely agree. It's incredibly frustrating and disheartening, and you want to try to give the benefit of the doubt, on these things. Bias is not a conclusion I like to draw, and it's just like at this point, it's a little hard not to. It's just like, it's just the way she treats experts. The defense wants to put on an expert. I need a voir dire. I need to know exactly what they're going to say. I need to make sure they're completely qualified in every domain. I'm going to check to make sure that they're not exceeding their scope. I'm like, okay. And then, the prosecution wants to bring on an expert there. And she's just like, in literally one paragraph conclusory order. Yeah, they're good. I'm like, how's that work?
Well,
It doesn't work.
I think I know how it works, actually. I think what the problem was, they set a trial date of April 1st.
Mm-hmm.
And if the trial did not start on April 1st, all involved would turn into pumpkins. And as the time went on and got closer, they were running out of time to do all of the things that really should have been done, such as if you're going to do the Daubert or Daubert, as you say, Daubert hearings for some of these people, then logic would seem to dictate fairness, fundamental fairness would dictate you do the same. But it was getting too close. And I think you also saw it in the adjudication of the motion to dismiss, which had a lot of meat on the bones. And there were a lot of unresolved factual questions, which probably should have been dealt with in a full-blown multi-week evidentiary hearing, but it was a week before the trial started. And I think there was just no time for this, which is obviously not the proper way to resolve these issues. But to me, I think that's what happened.
It could well be what happened, but even with the time crunch, the way she treats the two sides
Yeah.
is very, very odd. For example, like the past trial day where we have this amendment to a report or something like that. Like if the defense tried to do something like that, she'd presumably have a conniption. Because, well, she did have it. I don't have to say presumably. I know for a matter of fact, because when ARCA wanted to amend its report, it's like the end of the world, right? We have to have a voir dire. And Brennan's like, well, I totally don't want to exclude ARCA 2 months later. You know what I'd really like to do is exclude ARCA. I'm like,
Well,
yeah, I knew that 2 months ago, but thanks for telling me.
Well, it's like I said to somebody else, now that we're just apparently making this a kangaroo court and there's no
Mm.
rules, and we're all allowed to move the goalposts mid-trial because investigators still need to investigate. Presumably, what stops the defense from having ARCA do some other work, some other type of experiments, and coming forth right after the Aperture people get off the stand and say, we have new data which will kneecap these people. We'll get you a report tomorrow and we'll be ready to go. I mean, this Hank Brennan would have a stroke. I mean, he literally was whining a few weeks ago that he could not be prepared to start trial if he didn't get an ARCA report, which, oh my God, told him in advance how they were going to try to kneecap his experts, which, in the normal course, you get an expert, they get an expert, they do reports, you show them to the opposite expert, and your own expert tells you what they think. I mean, this isn't exactly rocket science or unique. And he somehow convinced this judge to turn it into that these lawyers, who are very good lawyers, very impeccable reputations prior to this. I mean, I know them all. They're good people. They're good lawyers. They believe in what they're doing. But we've been now told by this judge that they deliberately suppressed evidence that they were obligated to turn over, and then they deliberately lied about it. And then
Yeah.
after making those findings, how does a judge in good conscience not kick him off the case if you believe what you just said?
Yeah, I mean, I was listening to that. I like to think I was listening with sufficient attention, and I'm struggling to find the issue. I'm struggling to find the ethics issue, the rules issue, any issue. I'm struggling to find the issue. And she's like, well, this is she uses all the adjectives. This is lying, deception, deceit, skullduggery, but I'm not going to do anything about it. It's like, what the hell?
She did, though. She precluded them from opening on ARCA, which I think was unfair. And I think also, in the current context of the shenanigans you saw yesterday, it's even worse because the jury doesn't know, even just from an opening, whatever they recall from an opening. I mean, whatever it is, it is. But, they could have told the jury in the opening that we're going to have experts with degrees that are longer than your arm and who are going to say they did an evaluation, and as a matter of biomechanics, kinetics, this, that, every other scientific thing you can think of, that, it's going to be their opinion to a reasonable degree of scientific certainty that the prosecution's theory doesn't make sense, both as it relates to the damage of the car and as it relates to the damage of John O'Keefe. And that is more important to be out there right now in light of the fact that the prosecution is going to come in and take out an eraser. Everything that they said previously about the triggering event, we're just going to move it 30 seconds, excuse me. And the damage obviously has been done, but right now the jury doesn't even know that the defense has a smoking gun or had one until they decided to move the goalpost, that the prosecution's timeline was all kinds of fouled up.
Yeah, I mean, there's problems in every part of the case. I mean, we could spend for hours just
Yeah.
talking about the many, many issues of the case. But yeah, but speaking about openings of the case, I noted that you and I seem to have very different impressions about the strength of the prosecution's opening. So to sort of give my bona fides before I say something nice about Brennan here, I think that the case prosecution is ludicrous. I think that the evidentiary picture is in absolute shambles.
Mm-hmm.
At the end of the prosecution's case in the first trial, when they moved for that directed verdict, I would have really thought about it really hard if I were the judge, because I'm like, this is absolutely bullshit, and I don't think a reasonable jury could possibly convict based on this absolute shit storm of the stupid in every possible way, and sort of reducing it to its easiest to resolve level, which is always a good strategy in my view. It's like, I just don't believe it's really possible, let alone probable, a 7,000-pound SUV can hit a guy going 25 miles an hour, somehow create a disabling injury, whatever that would be, while also simultaneously not breaking bones, tearing ligaments, or even creating bruising. How can both those things be true at the same time? I'm not buying it. So I'm failing on the actus reus, as with the lawyers would say. I don't think it happened. And even assuming somehow she collided with him, it didn't cause the death because the injury wouldn't have been severe. So take your pick between act and causality. One of the two.
There's a but coming here.
Oh, yeah. Well, I was about to say nice things about the opening, but I was trying to prove out my bona fides before I said nice things. I thought, given what the prosecution has to work with, which, their case is an absolute shitstorm, but I thought, given that, I really liked the way that the Brennan opened the case. I thought my view of what the sort of perfect opening looks like is you want to provide an overarching story that you will then fill in pieces of as you go, so that
Agreed
you
so
have
far.
a nice narrative flow that gets things, and you drop in little pieces of evidence along the way to provide little bookmarks, but you don't try to prove your case like Lally did in his opening. So for my money, I thought that Brennan's opening, putting aside his stage presence problems, which
Oh
with his voice
God.
issues
Oh my
is
God.
is problematic as hell. But from a purely structural frame, I really liked the way that Brennan's
So
opening was done. I thought it. It started with a nice little energetic scene. We talk about the firefighter EMT getting the call. Get the energy. We rush to the scene, find the dead body, ladies and gentlemen of the jury. Blah blah blah. Lay it out, and I thought it worked out pretty well for my money.
So I agree with a lot of what you said. And certainly the whole idea of having a narrative story that, in theory, you could plug in the facts that go with that. And then the goal would be in summation to kind of go back to the story and the primacy, recency, and all of that stuff. The problem for me, and also putting aside his stage presence, which not just the voice, he comes off as a used car salesman to me. I
Yeah, a
mean,
little bit. Yeah.
there's smarminess that I think a lot of people, and maybe it's just because we see the way he acts, and so maybe the jury doesn't see it as much. I don't know, but the narrative that he chose, to me, he used this firefighter Timothy Nuttall as his anchor man for the story, and they came right out of the gate as his first witness, this guy Nuttall. And if you realize within 10 minutes of him being on the stand that he's not a very good witness. He's very impressionable. He's a guy who's going to claim, I hit him, I hit him, I hit him. That's his big takeaway. But he's also a guy, and this came out on cross examination, that also swore up and down previously that I remember as much as anything else, including I hit him, that the guy had a big puffy, Michelin man
Mhm.
style coat on, which obviously was not true. He also changed his story, and this could be a minor thing in isolation. I heard at the first trial she said I hit him twice. Well, now I heard it three times, and again, standing alone, you would say, who cares? That's two or three, but
Yep.
then but
I
then
thought
you
I thought I put up a picture of Brandon while we were talking.
then, then you realize though the I hit him has to be three times because we learned later that Jen McCabe speaks in triplicate. Everything happens in threes, and when he was cross-examined on this seemingly minor point, what did you find out? Well, what made me switch it was, I sat down with Brandon and Tully, and I now remember it was three times, but I'm certain it was three times. And you can just see that they took this very impressionable young guy, not a good witness at the first trial, nervous, literally hot under the collar. I mean, he was literally grabbing his collar with the heat, and they just molded his clay like brain into what they wanted it to be.
Sure.
And,
Sure.
and for that to be the guy that you're wrapping your story around and reminding the jury of and coming out of the gate, I thought that was foolish. In hindsight, I also wonder if Brendan did himself any favors by, claiming he mentioned something in his opening, which he thinks helps him in light of yesterday's events about, well, the times are not exactly synced up. And all he's really doing to me is showing that he absolutely knew what he was going to do with this aperture nonsense and if necessary, moving the timeline because he cannot be stupid to the point. I don't think he's stupid. None of us, nobody thinks he's a bad lawyer. He's not unintelligent. There's no way that he started this case believing the triggering event is at 12:31, whatever it is.
Mhm.
And I'm going to then have Ian Whiffen testify at 12:32. John O'Keefe is, pulling the phone out of his pocket, opening it with FaceTime, checking text messages. And at 12:31, to go back a minute, I'm also going to have Jen McCabe out there. Oh, I see him, or I see the car, not him. When she previously said 12:45, which she no longer remembered. Long story short, he had to have known that this was going to be a sandbag issue. I mean, I can't accept that this came up organically the way he claimed the other day and said this is a
Oh, no.
surprise.
Yeah, no.
But I always said it was a variance, so too bad for you, defense. I mean, I just find that to be sandbagging at the highest level and just unprofessional. And I mean, you can tell the guy obviously isn't worried about his reputation as a lawyer or prosecutor, because I can assure you that anyone who had a practice in with a opponent like who does things like that, the only thing that you're thinking about is how much of a scumbag this person is to do something like that mid-trial, where a woman is fighting for her life and her freedom, and all you've told us in advance of trial as part of his gaslighting, which he's really good at, by the way,
Yeah, he is.
is how much of a fair trial. I'm very concerned about getting the defense a fair trial, but not so concerned that I can't, erase the time, move the goalposts in so I can, kick an easier field goal. So the opening, I think, if the jury remembers any of that stuff and what they were being told, and with this thing with Nuttall, to me, Allen's opening was 1,000 times better because
Mm.
it was more emotional.
What was
Obviously,
that?
he certainly gives the jury the impression that he believes in what he's saying. He
Mhm.
believes in what he's going to, not, I don't want to say prove, but in terms of what the jury is going to learn, where Brennan was a monotone drone. I mean, with no modulation, which I found very surprising because he is very experienced. He has tried big cases, but I would have thought there might have been some inflection, some tone, some pregnant pause, something other than just droning
Yeah,
on
no.
in that tone for 45 minutes.
No, I didn't really have any of that, although AJ did have some great pausing where he had some great names where he took a beat to let a name sit or something like that. So yeah, his stage presence
Yeah,
is
he's a
much better.
master trial lawyer in terms of the art of persuasion and relating to a jury. And I mean, there's such a diametrical difference
Yeah.
between the two of them. And I think with everything that's happening in this trial, come summation time, that clearly is going to be, even though he doesn't get the last word, which is the most important thing in a summation. That's a huge advantage, though, for the defense is the style and stage presence of the lawyers.
Yeah, I mean, I certainly agree with some of what you said, like especially with respect to issues with Nuttall and respect to trying to basically cram a story into this poor kid's head and ideas like that. One of my more in the first trial, I didn't really feel like they really, at least to me, were able to really get the idea of she saying I hit him from anyone other than McCabe. I think that was really kind of all they really had in the first trial. For better or worse, I think in the second trial, they more effectively laid out the presentation with respect to EMTs and
Oh,
firefighters on the scene to say, well, here's, I don't know, what, 4 or 5 different people who say, I heard her say I hit him either in the background or directly or whatever. And I think while you can certainly pick apart any individual person, I think that the sort of accumulated sentiments that I'm fearful of is that the jury is going to just remember, well, I heard multiple people say I hit him, and they
well,
can't all be wrong or something. I think that's
well,
more of like a concern of mine.
I think obviously it's going to be the lawyer in summation their responsibility to clean that up and remind them. But one other point of the opening to me, which is a big deal. Different lawyers can do this different ways, but certainly when I was a prosecutor, and even when you're in trying a case as defense counsel, which I've done a lot more than as a prosecutor at this point in my life, there are certain issues are going to come up. You just can't hide from them. You've got
Hmm.
to deflate the balloon, and you've got to somehow let the jury know, and then say, "Look, I can deal with it. It doesn't matter." And so you get to the boogeyman in the room, Michael Proctor, and I think for the prosecutor to literally put him down the memory hole and erase him from the case at the opening and
Yep.
beyond was a huge mistake, and it's going to come back and bite them in the ass, especially when they dealt with Buchanan. But I think it also potentially may hurt them if the jury learns that they didn't call all the firefighters, they didn't call all the EMTs, and they didn't call any first responding police officers. And the reason is because they've all testified previously. I did not hear what they claim they told me about I hit him, or anything of that nature. Or, I didn't, as any police would do, certainly the NYPD in my experience would, if they showed up on the scene and you had a purportedly stinking drunk lady running around hysterically saying I hit him, at a minimum, they would have pulled her aside and say, what do you mean? I don't even think they would assume by a car, by the way, but just
Hmm.
tell us what you mean. And they would also make reference to, what, she kind of stinks like whiskey or whatever she was
Hmm.
drinking.
Yep.
Uh, they would note her observations. Is she unsteady? Excuse me, on her feet? Does she have the bloodshot, watery eyes? All the indicia, and none of that was done. And they didn't call any of these people. They're
Right.
clearly cherry picking what they're doing. And I don't know if Brennan just forgot how to be a prosecutor, but when you're wearing the white hat, is the word I use to describe it, the jury kind of expects you to like tell us what's going on here. And I don't blame them as much for not calling every single person in the house like Lally did to prove a negative, which was a curious thing to do. But by not calling the cops who would have been there to see and hear these things, not calling Proctor, not calling Tully, I don't think he was going to call the medical examiner until maybe a day or two before he did. That he was concerned that would look like he was hiding the ball too much. But I mean, but even the people who said I hit him, what did you learn later about, Nuttall, for example, that according to, was it Katie McLaughlin, the one who is friends with the Albert daughter, who but refuses to tell you that I'm friends with the Albert daughter, which is one of these things like, why are you dying on that hill? But what she did say was that Nuttall was in the ambulance when this was happening. So like,
Hmm.
both of these can't be true. And Jennifer McCabe is not credible on this point
No,
because
absolutely not.
he is literally no credit. And I mean, a lot of the trolls get excited and triggered, but she was
Yeah.
methodically crossed on every single time you spoke to any law enforcement officer about what happened. You never said this.
Right. Or at her grand jury testimony when she was asked multiple times. Yeah,
Right.
exactly. All that stuff. Yeah. Jen McCabe is a lot. I kept changing the description of her in my stream. I kept changing her like leader of the Nazgul, voice of Sauron. Just came up with different ways of describing her. We had a lot of fun.
Yeah, no, she was. I think she was obviously not an effective witness. But one of the things that Brennan did with her, and I've seen this now as a pattern through a lot of other witnesses, including Buchanan, the medical examiner. I'm probably forgetting other ones. His redirects, putting
Hmm.
aside that they're improper in format. I mean, the idea that you can just lead at will, but putting that aside, he has made every witness worse in attempting to what he perceives clean up or reestablish anything that happened on cross, where he's just getting clobbered on recross. I mean, I only thought of this because we were talking about Jen McCabe, but if you recall on her redirect, he wanted to talk about like how cooperative she was with the police, and every time, except for the FBI, of course, who
Hmm.
trying to find out what happened. That was, a different situation. Or when he was talking about, because there were some harmful family text messages in their little private conversation about, she's telling him everything and all, tell him the guy never went in the house, those kinds of messages. And on redirect, he somehow got in inadmissible text messages from her friends where they were kind of sharing their grief about what happened. But it was really effectively established that, but that's with Kerry Roberts and other people on the outside. But behind the curtain, under the kimono, when you're talking to your people, the McCabe's and Alberts privately, you guys are talking about, she's telling them everything. They want to know this. They're over here. Tell them this. And nowhere did anybody say how distraught they were about John O'Keefe. In fact, he
Right.
wasn't even called John O'Keefe. He's just the guy.
Yep.
So, and all of that would not have been emphasized for the jury if Brennan would, think before questioning on redirect. And he's done it again and again. He did it with the medical examiner the other day, where he tried to like sum up the case about, well, did you know this? Did you know that? Did you know about the statements of I hit him, and all the other stuff? And the medical examiner said, well, yeah, I did. I was made aware of that. Putting aside whether that was improper, it took Bob 3 minutes on recross to say, well, now that you know all that, did that change your opinion on an undetermined manner of death? And the answer was
Yep.
no. And I mean, talk about nuking your own witness.
No, I mean, yeah, I mean, there are a lot of problems. His redirects have certainly not been clean. He's been pretty good on direct, but the
Yeah.
redirects he is not really doing super effectively. I think so. And at the moment though, it seems like we're in sort of the dumping ground of the case, talking about primacy and recency. I
Mhm.
think, the sort of act one of this case was, basically the confession, the admission. That's what he wants
Yep.
to characterize it as. And now we're in sort of the shit sandwich portion of the case. And presumably he's capping this thing out with his strongest physical evidence, presumably ending with Aperture, because he believes that, Aperture is going to prove that this physically could have occurred. And I think that's strategically what he's doing, because that sort of makes logical sense. But I agree with you that on the Proctor thing, I think it's a strategic mistake because the idea of drawing the sting is sorely well known. Proctor's a disaster area. It makes more logical sense in my mind to, as the Commonwealth, to call Proctor. You ask the questions the defense is going to ask, but you ask them more softly so
Sure.
that you get ahead of it, and you cushion the blow, and you don't give the defense really anywhere to go because ideally they've already heard it from you, so you kind of neutralize it, you gain a little credibility, and hopefully that works by apparently getting the defense to do it. He thinks he's going to rehabilitate this all and cross somehow. How's that going to work?
I think it's a double whammy. I agree with everything you just said about you call Proctor and, look, as a prosecutor, you sit him down and first of all, you find out where his head is. I mean, you call him assuming he's not going to, sandbag you or go rogue because he's upset about everything. And, you tell him, look, this is going to be a bumpy ride. This is buckle up. There's going to be a lot of turbulence on this flight. Just get used to it. And then if I were the prosecutor, I would tell him, and when you're on cross, don't look at me for a lifeline. You're like, don't even look at me at all. You need to take your medicine like a big boy and we'll deal with it. So that's what he should have done. But putting aside that, if you're not going to do that and you are going to try to have Buchanan carry the whole weight of the world
Mm.
as far as the Massachusetts State Police are concerned, could you at least prep him? I mean, how do you decide that you're going to use Buchanan as the good one, but yet you're going to die on the hill of whether Michael Proctor was the lead investigator when guess what?
That was a really stupid thing to fight over. That was
Everybody
so
knows,
stupid.
everybody knows he was the lead investigator. In fact, everyone else who's testified from the lab, from the other state police, of course he was. So you die on that hill. You
The
fight over.
colonel called him the lead investigator in the dismissal papers.
So he makes it that much worse. So I just think they look like they're hiding things from the jury. And Brennan to me, as far as being a prosecutor, going back all those years, I mean, he's sacrificing his most important stock in trade, really his only one, his credibility. I mean, as you know, the case is difficult and you need a really persuasive and charismatic prosecutor to talk to the jury and say, here's my hand, hold my hand. I'm going to walk you to the finish line, but you can trust me. And here's how we're going to navigate through this minefield. And instead, he just keeps doing, what I call, that the Wizard of Oz technique, which is, never mind that man behind the curtain. Forget all that. Just pretend it didn't happen. And I don't know why the jury would look at him at the end of the case and say, I think you're doing this straight.
No, I think in terms of blows to his credibility, I think that you have a lot of problems there. And with Proctor, I mean, there's a lot of different ways that can blow up in your face. So I'm not disagreeing with you.
That's going to blow up in his face. I mean, however effective or not their new data is, and you can get into a whole nother discussion about how unfair that was. But if you accept the fact that this guy Burgess is really with a straight face going to testify, that I changed my opinion after Ian Whiffen testified, and wouldn't you know it, it sinks perfect now. On cross-examination, that guy is going to get bludgeoned like no one else. But the real loser there is going to be Brennan because, jurors are going to be looking at him and saying, what kind of bill of goods are you trying to sell me, guy? Like, what are you kidding me right now with this? I mean, he's damaging his own credibility in my view.
Yeah, I think all that is true, but I'm also, I don't know, maybe I'm just a little bit from the first trial in particular, because apparently 6 or 8 members of the jury were apparently ready to convict on some version of manslaughter. According to the one juror that Turtle Boy interviewed, I saw parts of it. Apparently some people in the jury were saying, well, Karen Reed was there, John O'Keefe was there, therefore Karen Reed did it. And I'm like, I need some other steps in between. And I'm like, if they were ready to, if half of them were ready to convict based on that absolute trash fire of a case, I think, whatever can be said about Brennan, which is many things, I think he has organized things better. I think he has laid the witnesses out in an order that makes a lot more sense. I think he has led with the confession, presuming he, ends with some really strong stuff from Aperture or a new Emmy or this dog bite expert, whatever his best, let's say, physical evidence is. Let's say he ends with that, or he even dumps it into his rebuttal case and just brings it into his rebuttal case. Then he makes, the twin themes of his closing and rebuttal closing, the confession and the physical evidence. And, I figure, I say that there's a 5 to 10% base chance that on a given day, the jury convicts the defendant just because they're sitting there. If not guilty, why not guilty shaped? You throw in the fact that it's a dead police officer, and that's got to probably up the odds. You throw in, the fact that as I'm sure you're well aware, the Innocence Project will be happy to tell you, confessions or perceived confessions go a long way.
Of course.
Jurors have been known to sometimes ignore physical evidence to the contrary of confessions because of how powerful confessions are. You throw in some, wizardry, physical sciences from Aperture, and I've tentatively scored this at a 60% chance of some kind of conviction, which maybe I'm out of my mind, but I'm also a little jaded and cynical. That
That
isn't,
must
by
make
the way, to convince me, because convincing me is a whole nother set of problems.
that must make you very popular
Yeah, no,
online.
I'm not really popular right now. No.
Figured. Um, I mean, look, we're lawyers. We give opinions, and if it's backed by reasonable analysis, it's just an opinion. The biggest concern that I have, and it's part of this whole case as a whole, which I think has just been handled in many ways as a complete joke, is the jury selection. I mean, the manner of jury selection in this case. I've talked about this with other people before. When I was brought up in the Manhattan DA's office as a kid lawyer, the geniuses there who were the basis for the Law and Order prosecutors would come in and tell you, when you're doing jury selection, you're trying to do two things, right? Brainwash and get rid of the kooks, and everything else goes from that. And you get a jury that you're satisfied, you got some degree of brainwashing, you got rid of the kooks, you're in business. You go from there. This case, the way they did jury selection, they were calling one juror at a time at the bench, no
Mm-hmm.
panel, and
Mm-hmm.
no even knowledge of when they pull out a juror who's next in line. So, in terms of using peremptory challenges in this case, you couldn't even see the chessboard. You couldn't even look. I need that one down there. So, if I strike that one, you're going one at a time and you have to make a decision. Am I picking that? Which, at least in New York, you only do that when you have a jury and you're picking alternates. By then you start going much shorter. But they picked each juror one at a time without even knowing what could come next, and where are they with their challenges. And I find that in a case like this just awful. They couldn't sit down a panel. They couldn't run answers off one juror to another,
Right.
see what the
Right.
actions are, see who's talkative, see who's staring at the floor, who's rolling their eyes when somebody says, well, if a police officer testifies, it has to be true. I mean, none of this is going on. And I think that definitely is a huge disadvantage for the defense to me. I agree.
I haven't ever really thought about that aspect of jury selection, but you're completely correct. The way that they
Horrible.
drew them one at a time, yeah, the fact that you can't see the panel dynamics is a restriction of
Atrocious.
information. So,
Yeah. Terrible.
do you think that also plays negatively towards the prosecution, or do you not think it's as much a liability for them? I mean, because obviously jury selection was done the same for both sides. Do you think
I
it's a
mean,
bigger problem for the defense?
I feel like it is, although, in all fairness, obviously they're both saddled by the same issue. If you can't see the big board and who's next, that does affect both of you. But, to me, it's a defense case. I mean, it ought to be an acquittal based on common sense, the evidence. So I feel like the side who is on the other side of the case that has a longer shot somehow benefits from the chaos and crazy. As you said, how did some of these jurors the first time conclude the way they did? I feel like having an unpredictable jury selection would tend to favor the party who, other things being equal, would be less likely to prevail, which I think would be the prosecution. So, to some extent, in my mind, the chaos in jury selection actually helps them.
Yeah, I think that's quite possible. Let me ask you on AJ's style. I felt like he came in too hot for my taste on cross with those early witnesses, because we were talking earlier about your credibility and likability as being huge factors for the jury. I think AJ's style worked very well for more of the police witnesses, because there's more juice to be gotten. But I felt like he came in just overly aggressive and kind of bullyish. But if you disagree with me, I'd be interested in your perceptions with respect to
Yeah.
those like early EMT firefighter kind of witnesses.
So yeah, I do disagree. Actually, I don't think it was anything overly aggressive. I think using tone and manner to kind of lead the witness to know. I'm not getting what I know you know and you're not telling me. I don't think it crossed the line. Like a perfect example, I think it was Nuttall. Nuttall's whole position was I hit him while we were doing chest compressions, and this guy was doing this and I was doing that. And, but the conduct that he was describing was on the dash cam video or one of these videos with sound, and you don't hear anything. And he was trying to establish through the witness that, it's not happening the way you said it. And the guy was either not understanding him, making no sense in terms of what he was saying. And it didn't offend me at all that what the lawyer was doing was making it clear to the jury that this is wrong. Pay attention. I don't think it was overly aggressive. I don't think, it's an ET. It's not a police officer, obviously, but you know what? It's a public servant. They respond. They're big boys and girls. They can handle it. I don't, it's not like they went after Peggy O'Keefe. He didn't ask her a single question.
Yeah, no, when he got up, I thought he was going to cross-examine. I about died. I was so glad when he didn't ask a question. I was like, okay, the trial can continue now.
Right. But so I don't think his tone, I mean, I don't think you're alone in that assessment, by the way. And maybe it's just because I'm, where I come from, we all have very sharp elbows, and there's a lot of that. To me, it didn't bother me at all. He was flagging for the jury. This is important. And I think he was doing it at the right time. I don't think he was, nitpicking over nonsense. At least with Nuttall, what are we talking about? We're talking about, the circumstances of your claim that I hit him. I mean, that's the whole point that they need to get out in that cross, is that it doesn't comport with the evidence that's indisputable, the dash cam. I mean, yeah, I mean, and I'm sure there's other examples that, you can point to, but I wasn't bothered by it at all.
Yeah, no, fair enough. I mean, different people are going to have different perceptions, which is one of the reasons I wanted to ask you about your perception.
Yep.
And to be fair, my work as a lawyer has been almost purely transactional, so I don't have a lot of trial experience.
You guys are nice guys.
We do it differently. I don't know. It's all paper.
Yeah.
Yeah. I mean, I was a patent attorney for most of my career, so we're trying something different now. So
that's pretty different.
That's all right. Yeah. No, I hope at some point to get into like federal civil appellate stuff, but the YouTube thing has been interesting, at least in the meantime, while I try to do something else. All right. So let's see what else. So where do you think, what is your, because I have sort of my theory of how I think the case is going to develop from here. So based on, the first trial and based on what you've seen from Brennan, what do you think sort of is the layout of the case from the Commonwealth? And it looks like the defense is going to do a much more robust defense. So I'd be interested to see what you think, what they're going to do in terms of the defense strategy, in terms of the differences there.
So, I mean, I agree with you in terms of what I think Brennan is doing. That, the first wave of the case clearly was she admitted she did it. Mm-hmm. And then the next phase was she was drunk. We have all this evidence of intoxication. And then I agree with you again that now you're kind of in that mishmash meatloaf part of the case where he threw in the medical examiner that he probably didn't want to do. And he's leading up to what he thinks is the big finish, which is, science. Science is going to win the day. And we're going to prove that, medically and forensically with the cell phone stuff and the telematics or whatever you call it from the car, that this is when the accident would have happened. It's obvious to me that he's streamlining the case and that he has no interest in calling any other police officers. He's not going to call anyone with the last name Albert, which, there's risk. The jury, the risk is when the defense gets up in summation, you know what they're going to say? We had to do this. We had to do all of this. So I do think when they get up, I'm definitely calling Proctor if I'm the defense.
Oh, yeah. I can't think of any way that really goes wrong, because it doesn't really matter what he says. Every answer is equally great. They're all good.
Exactly. We're totally in sync on that. He's what I call house money. There's nothing he can do to hurt me. I'm definitely calling Brian Higgins because not to prove, never mind the third party culprit stuff. I think that was way out of hand the first time, way too
Mm,
far down
mm,
the rabbit hole, as
mm.
opposed to just being part of reasonable doubt. It felt more like they were trying to prove that, it was Colonel Mustard in the conservative candlestick kind of thing. But, there is a lot of evidence out there that Higgins is the weird guy in the sense that
Oh, dude, man.
we saw the
Dude, that
video at the
that dude
bar.
that dude with those messages, I wanted to die. I
You,
forgotten how bad they were when
yep.
it went through them again. I had
But
forgotten a lot of that. I was like, "Oh shit, dude." I
now
was like, I'm like, what conversation exactly are we having? I don't even know what conversation we're having as Higgins.
that's no.
What am I trying to do? I don't
I
even
don't.
understand what's going on in this conversation.
I don't know what the hell that was. But what they did this time, those messages are now in the context of look at Higgins in the bar. Look at him huddling up with Brian Albert. Look at him looking at his phone. Look at him looking at Karen, who is not lifting an eye towards him at all. And then you see at the end what I think is pretty powerful evidence. You clearly see Brian Higgins agitated, pointing, come out. He's clearly looking in the direction of John O'Keefe.
Mm.
Chris Albert is clearly trying to calm him down. So you know all of these things. You know that he testified at the first trial that when I left the waterfall, I just left. Everyone was cool. What did he say? Like his Irish exit or whatever they call it. He just, everyone was happy. That's not the case. About the message, are you coming to the house? That's kind of weird. About this video now where he's going to the Canton Police Department, presumably drunk out of his mind to move cars for no good reason. And then it turns out he doesn't really go there to move cars. He goes there to get something either out of the office or out of another vehicle, which is a little weird. You now know.
After drinking heavily in a
Right,
snowstorm.
right. You
Yeah.
also, now know, I mean, his lawyer was with him during the first trial, but the prosecution is trying to portray him as a classically meaningless, irrelevant, knows nothing witness. And now it comes out, he gets interviewed by the state police 2 or 3 days later, and he's got a lawyer. And of course, lawyers never criticize people for getting lawyers. But in the context of who he is in this case, he's the one that had the lawyer, nobody else. He's the one who says, come to my lawyer's office or house. He's the one who says, I'm not giving you my phone, I'll give you these messages. Okay. He's the one who the jury doesn't know tossed his phone on a military base the day before he got a preservation letter, the same as Brian Albert. The jury doesn't really know, not conclusively yet, that these two, Higgins and Albert, had what I call the first conversation by butt dial, probably in American cell phone history. I mean, they literally
Yeah.
communicate by butt dial, so they don't know all of these things. So I'm calling him. I mean, if I'm the defense, and then you're certainly creating a lot of issues, and I'm calling Brian Albert because the jury needs to know how close his bedroom window is to all the stuff going on outside his house at 6 o'clock the next morning. And, I give Brennan a lot of credit for doing what Lally did in the first case, which I thought the judge, should not have done, or at least they should have a second crime scene visit. When they went to the crime scene in this case, they went before anyone from the house testified, before there was any real relevant evidence. And the jury doesn't even really know the significance of what I'm talking about. That if you were looking from Brian Albert's window and then you see the flagpole and the fire hydrant, it's real close. It's a very small front yard. The idea that he didn't hear something, the dog didn't hear something, the wife didn't hear anything. So, those three for sure, I'm calling. And I'm actually considering calling Nicole Albert, the wife, for the same reason about the wake up the dog, but also the 5 o'clock phone call that connected for 38 seconds that neither she nor Jen McCabe will even acknowledge. I'm calling her for the sixth, right after the 911 call, the other phone calls where you can hear Jen McCabe whispering. She's either talking to her or leaving her a message. I'm also calling her now because of this kind of fiasco that you heard about the dog that apparently got renamed and was delivered via third party and transferred. She testified at the first case, I believe.
Yeah.
I drove the dog and I met someone at a rest stop and it was sad and said goodbye, and that was that. These are all things that don't look great for these people, and that the DA is
I
just
refuse. I refuse to believe it's the same dog. I demand proof of life. I don't even know what that would look like. I want Chloe with a copy of USA Today or brought into the courtroom or something. I don't know, man.
I mean, the
I don't
way they
know.
handle that is so freaking suspicious. And again, if it's a nothing issue, then why are they handling it? Why did they handle it in such a weird way? I mean, the dog is a biter. They know that. The defense does have experts who are going to say that prosecution will dispute it, whatever. And yet nobody. And another thing I think the defense has got to hammer on, and another reason you would call Brian Albert and Nicole Albert is, if Jennifer McCabe didn't wake up the dog after the fire engines didn't wake up the dog, shortly thereafter, when there's 3 police officers and 6 people standing in the foyer of the home, the dog would be down there for a couple of reasons. Number one, there's a lot of people in my house. That's number one. Number two, I'm hungry. I'm a dog guy. I don't know if you're a dog guy. Dogs eat. And in the morning, they need to be fed. They would come down. And perhaps most importantly, dogs also have to pee and poop. Okay. And by that time, somebody would have had to walk the dog, let it out. It would have been barked. Nobody, as far as I know, police officer or witness or anyone, has ever testified that in those hours when they're all huddling in the foyer of the home, that there was a sighting of the dog. And that strikes me as literally impossible as a dog owner. And I don't know if there are dog owners on the jury, but I assure you, if they are, they're all going to recognize that.
Yeah, I mean, and why did we get rid of the dog exactly? What was that all about?
Because it bites.
Hmm.
I mean, that's
Well,
but
presumably that had been a problem for several years because they had owned the dog for 7 years at that point, I believe.
yeah,
Yeah, so that wasn't a new problem. So why did they
that's
get rid of the dog?
that's another key. And again, I don't know how they did jury selection, but a dog owner is going to raise their eyebrows and say, what would it take for me to get rid of one of my dogs? Okay. Now, obviously, biting, not good. Okay. Doing things, not good. But you don't just give up your family pet of 7 years. Okay. Most people who have dogs actually treat their dogs better than people in their house. That's
Yep.
just human nature for some stupid reason. They worry more about you go on vacation. What's the one thing you worry about? The pets. How are the dogs? How are the dogs? You don't just get rid of your dogs. And when you saw the testimony in the first case, when they testified about getting rid of Chloe, it wasn't even emotional. It was very calculated. Just they didn't even call their dog Chloe. It was it. They called their dog it. I don't think you've ever called your own dog.
No. Yeah, no, that doesn't make sense to me.
No.
So there's so many things about this case that don't make sense to me in
Yeah.
terms of like just so many elements of the case. It's hard, and then of course always in the end as always the solo cups, because we cannot forget the magic that is the solo cups. The solo cups are real.
As far as the whole manner of gathering evidence and crime scene disgrace, the problem, I mean, the solo cups are bad. I mean, the Stop and Shop bags are bad. The leaf blower, it's bad. You laugh, but they're actually not even the biggest things for me. On the abandoning of the crime scene right away is far and away just a much bigger deal, because
Sure.
once you lose the crime scene, you've lost the integrity. And now the defense is making crazy arguments that somebody came by and sprinkled taillight. If you secured the crime scene and you had witnesses who could say that's impossible because we had a chain of custody of the crime scene, for lack of a better term, from every moment up until the point where they found the taillight pieces, that argument goes in the garbage. It's not even plausible. And the other thing, which I can't get by, whether it's Proctor or Buchanan, and they didn't ask Buchanan, I don't think, maybe they did, maybe I missed it. But, when they went down to fetch the vehicle down at Karen's parents' house, they already had ordered a tow truck for a vehicle. They had no search warrant and they took it anyway. And I'm just going to pretend we're not talking about that because that makes no freaking sense to me. Same with their phone. I mean, where I come from, we still have a Fourth Amendment and it's search and seizure. You know, you need probable cause for both. Putting all that aside, but their testimony is we basically knew this was a hit and run. We knew the car was not a manner of transportation, it was a murder weapon. And we knew when we got there, we saw that the murder weapon literally was a smoking gun because we saw the whole right tail light was busted out. And neither one of these morons picked up their phone and either filmed a video or took a picture and said, you know, not that you're going to have a newspaper, but you'd have metadata. It's January 29th,
Right.
you know, 4:30 p.m., whatever. We just arrived here and boom, here it is. And at that point, there would be no issue about the condition of the taillight. And these idiots never did that. And I can't accept.
How does the tow truck driver not do it? Isn't that just pretty standard practice for your own liability to document the status of the car before it's being towed so that the owner doesn't say, hey, you scratched my car? Be like, no, here's the picture I took of the car before I loaded it up. It clearly has a scratch. This is you. This is you. Isn't that pretty standard?
It should be. And, you know, I'll give him a little bit more of a pass because number one, he's not a cop. Number two, it's a blizzard. I'm cold. I'm grabbing a car, whatever it is. But I'm going to the police and I'm saying, this is crushing proof. And it can't be that they're too stupid because they've investigated other high profile murders in that county and they've done good investigative work. And, you know, then it turns out.
But never in the snow before, as we learned from the first trial. Never in the snow before. Apparently, it never snows in Massachusetts. I did not know that. It never snows in the state, so why would the police have any experience? It must,
But then they lie. Proctor lies under oath about the time they seized the car. They change the timeline so that it doesn't fit with the recovery of evidence. They have a million excuses for that. And, you know, the problem is it's just one coincidence on top of another, uncorroborated conveniences. And when, you know, a skilled advocate in summation, you know, you start putting each pebble on the scale and, you know, you're dealing with reasonable doubt, the scale is clearly balanced in your favor. And, you know, you're blaming it on the witness who they didn't even call. And maybe this is one of the reasons they didn't call because, you know, I mean, for example, Buchanan said he's a great investigator, but he didn't take a freaking picture of any pictures until 3 days later. He didn't go to the crime scene for days. That makes no sense.
Yeah, I would think that would be relatively basic step. Where literally scene of the crime is probably a pretty good place to start. I don't know.
Seems pretty important, one would think. Yeah.
Speaking of solo cups, by the way, for those of you in our wonderful audience, we do have some wonderful merch items from our merch store. So I'll take a moment to plug my own merch. We have, for example, this wonderful evidence solo cup that can be yours. The property of Canton PD, but it can be yours. Get your hand on this Evans Solo Cup, a 100% glass tribute to the Canton Police brilliant choice of unsanitary solo cups. It can be yours from our merch shop, plus other wonderful merch items. Don't feel free to check it out. I'll send you a cup, Mark.
I'd love that.
I'll send you a solo cup, and you can have it on your shelf or something.
I'll put it next to my witness intimidating rubber duckies. Yes, thank you.
The witness intimidating rubber duckies are real. We've also got some the Canton PD CSI shirt. This one I designed myself. Got a lineup of all the various CSI tools. You got to have that in your life. That's important. Of course, we are big fans of the Spinny Fan. The Spinny Fan is the best fan. So we got some great Spinny Fan merch that you can have there with your cup and stuff like that. And of course, for your sidebars, because you need a drink and I do too, your choice of whiskey glasses or wine glasses, check out our merch shop today. Fun things. We'll get Bev one too. I'll send it that you can give it to her personally. That'll be good.
That's very clever merchandise. That's the best I've ever seen.
We do what we can. We do what we can over here. Thank you. Yeah. So what do you, I mean, you've certainly worked enough jury trials. I mean, you know how juries work and as fact, you know, versus what they should work in the ideal plain. In the Platonic ideal, beyond a reasonable doubt, and it's like, well, I can just find any
Yeah.
doubt, and I'm done with it, and I can go home. My perception, but you would certainly be more equipped to answer this, is that juries work on a combination of feels and vibes and overall zeitgeist, and I how I know that there's a lot of ways that a jury looking at this could obviously say beyond a reasonable doubt, but you know I mean, we don't know a lot about this jury for a lot of reasons, but I mean, if you had to like score this case based on probabilities of conviction, not of course what you personally think in your own mind, and maybe you're too close for this question, but I'll give it a shot anyway. If you had to score like the probability of the prosecution walking out with some kind of conviction on this case based on their presentation, what would you assess the probability of that based on where we are, and also your a reasonable estimate of where we think we're going, which is pretty informed by the first trial, but not completely.
Yeah, I mean, we're having fun, obviously, but this is a very difficult exercise because the evidence is still coming in and all of that. So, but for me, I will be surprised if the prosecution gets 12 out of 12 to agree that there is no reasonable doubt on any of the counts, for the simple reason that fundamentally the first thing they're going to have to prove is that there was a contact between the Lexus
That'll
and
help.
O'Keefe. Now we all know the first trial. I understand that, but it's a different jury. I don't even want to factor that in. But to me, the ARCA guys are going to testify. Now the first trial, when they testified, it was kind of a fire drill. Notwithstanding the fact that Hank Brennan thinks that Alan Jackson and Dr. Wolf, or whatever his name is, were having sleepover parties and preparing and doing hours and hours of whatever, and then going to Signal and telling each other how do we fix this case and get you paid. Putting all that nonsense aside, this time they're going to be able to actually talk to them and prepare them and think about what that is. So unless the DA can win on the point of the contact between the car, and by win, I mean overwhelming, I mean, it can't be close. They have to kneecap that issue. They have to wipe out ARCA. And presumably they're going to do that through Aperture. And let's just say all should be concerned, if nothing else, based on what you saw just in the last few days, that Aperture's report is so effective that they felt compelled to alter it in the middle of trial because it didn't match what Ian Whiffen said. I mean, that's how it was described to us the other day, that this Burgess guy acknowledged, and credit for being honest, that, I wanted it to kind of align with what Whiffen said, so I'm going to make it better. So you now know that the initial report that the prosecution brought this case to trial on is not accurate by their own admission. They didn't get it right, but he's going to get it. But ladies and gentlemen, he has it right this time, and ARCA has it wrong. He also, I don't know if you remember this, in one of his initial documents in which he was entering into the case, when they searched the telematics of the car to get access the device, he apparently, and I'm not a science guy, so but I accept what all these people are telling me he screwed up gigabits and gigabytes, and it's a big difference. And
by a factor of 8.
Right. Well, there you go. So you're a better science guy than me. One would hope that a so-called expert on telematics would know the difference between the machine, if it's gigabytes and gigabits, and how that can impact whether what you're going to do makes any sense. They're also saddled by the Trooper Paul fiasco.
I miss Trooper Paul. He's the best.
Well,
he's the greatest.
I expect that the Aperture witness will be reminded, and it will be made clear to the jury that this is what we call a do-over. Okay, we tried it with this guy the first time, but he's about the worst expert witness, and that's being very liberal in the meaning of an expert witness, because that guy was no expert
Yeah,
eventually.
how that guy makes it past
Yeah,
Dover or Fry or anything
right,
is beyond me.
right.
Uh,
But they're gonna
do
crush.
you know what acceleration is?
Oh,
Forward?
I was actually there the day, like literally.
You were there in person,
I was,
and
and
you lived through the experience. I would have died inside.
well, apparently, I might have dozed off actually for a few,
Oh,
but
okay.
well, it was it
That
happened.
was your brain trying to save yourself. It's like the
It was,
only way I could save this is by putting my own body into a coma.
it was a
Let's go with
long
that.
day.
Yeah.
It was Trooper Paul and Jessica Hyde. It was a lot. It was a lot to bear as witness to what was happening. But the point is, you know, they're going to ask the Aperture guy, "Did you review that? Do you agree? Do you disagree?" What they're going to have to disagree. They're going to have to basically say this is ridiculous. The ARCA guys are going to come up and they're going to like outgun. Okay, I mean, in terms of their credentials, this guy Welcher. I mean, the ARCA guys. There's a reason why the Justice Department hires them. There's a reason why the Army hires them. There's a reason why the National Hockey League hires them. They're top level people.
They're pretty good. Pretty good.
And if Brennan's cross examination, and I still refuse to accept that he's going to do this, although seeing the histrionics you saw from a few weeks ago, where he was swinging from the chandelier about the art conspiracy and all that in the latest voir dire, I still find it hard to believe that his takedown of them is going to be that you prepared with the defense, you had text messages that you deleted, you used Signal, you got $500,000 from the federal government. Okay, well, excuse me, from a third party. My bad, a third party who hired you at a time you didn't even know who the defense was. You rendered an opinion without knowing who the defense was. You were then given equal access to both parties. Prosecution didn't even bother trying to talk to you. And
Mm-hmm.
then the defense understandably did because it was exculpatory. That's normal. That's called being effective. They talked to you. And then, oh my God, when the case was over, you submitted a travel and expense voucher for $20,000 and they paid it after the trial without any
Mm-hmm.
discussion of it beforehand. So therefore, they're not credible. If that's his line of cross examination, then you, Hank Brennan, are a fool. Okay, if that, especially by the way, Aperture, who hired them? The district attorney. Who paid them? The district attorney. Who changed their opinion? Them. Who communicated with them? You. Who violated the so-called sequestration order? Aperture, that you were screaming about ARCA. You
Yeah, no
know,
joke, right?
I, so like he's throwing rocks in glass houses and all of that stuff. And if they can't win that issue by saying everything the Aperture guys said, including
It's
changing their
bullshit. Everything this guy says bullshit. Just do a
oh,
Vinny.
they
Like
but
as a
they're
Vinny.
show that those guys are beyond reproach in their analysis, their new analysis, not the old one, because their old one would show that John O'Keefe used the phone after he was dead. Can't have that. So, but their new opinion is unimpeachable, and the ARCA guys are paid hacks. They're not qualified, and they're in the defense's pocket. And I don't know how in the hell they're ever going to get past that. And that's without all the other problems in the case. So, which you could go on, not just the Proctor stuff, not just the taillight stuff, not just the Google search, because the Google search is another issue, like the accident reconstruction, that really is house money for the defense.
Mm-hmm.
They have the prosecution has to win beyond all doubt that there was no Google search at 227. If the jury even thinks it's plausible, then the case is over, because that would mean Jennifer McCabe doesn't mean she killed anyone, obviously, but it means she's doing something she shouldn't be doing because she knows something she shouldn't know, right? So, but so far you've heard two experts who, they weren't the worst experts you've ever seen, but I didn't find them over the top compelling. And you're still going to have a defense expert. And, like Whiffen, I think he was fine for this issue. But he also acknowledged that there is an equally credible software program that I did not create, which still says it happened at 227. And I think with Hyde, the risk is they just lost the jury because, you know, her testimony turned into talking about waffles, pizza, and hamburgers. And I'm sorry, like,
Yeah,
again, I just don't know what the hell
that
we're
was
doing.
hilarious to me. That's hilarious. My undergrad is actually computer science, so I was dying a little inside during her testimony. I'm like, waffles. I was like, waffles or something. But you know, it's a pepperoni pizza, and that's sad, and we got to
I
send it back.
I I don't know why she veered down that rabbit hole. I mean, she's obviously very intelligent at what she does, but you know, at the end of the day, I don't know that this is so overwhelming and so compelling, and that the science is so overwhelming and so compelling. They didn't secure the crime scene. So it is plausible that that taillight got there unnaturally, particularly if the defense says there's no car accident, which means how did the taillight get there? And we haven't even mentioned the medical examiner, who was a freaking disaster for the prosecution. I
Yeah, I
mean,
mean, she basically admits that the evidence does not really support that this was a motor vehicle collision.
she,
That's
she
kind of that's kind of important.
it's even worse. I mean, the defense could be in a position where they could get up and say, ladies and gentlemen, you know, the issue here is, you know, their allegation that Karen Reed committed murder or manslaughter, both of which are forms of, wait for it, homicide, which is just, you know, the killing of one person causing the death of another. That's all it is one person causing the death of another. And not only is there no evidence that Karen Reed did this, there's no evidence that this was even a homicide, period, full stop, beyond a reasonable doubt, right? I mean, their own medical examiner said there are various manners of death. One of them is accident. One of them is homicide. Some of them don't really apply. I mean, obviously, it's not natural if you have a big hole in your head and that kind of injury. But if she couldn't even tell you definitively as a medical professional that I can't tell you with any degree of confidence that this is not an accident as opposed to a homicide, what the hell are we doing here?
That is a very solid question. Yeah, it's like, yeah, how are we continuing on with our day? I don't know.
I mean, you
And you
could
just you,
literally
you just you
say,
just add it, and it's just like, it's like, how many things can you explain away as the government? How much large yes do you want me to extend to you? I understand no investigation is perfect and things happen, and we live in the real world, and sometimes things happen, but it's like, between all the various things, lack of evidence logs, apparently we're taking samples at the lab from which cup we don't know which, and also we're not testing the swab, so I don't know why we're taking them in the first place, but we took them for some reason. And then the solo cups and the unlabeled containers, and they're unprotected and uncovered, and we couldn't find any plastic pieces during the first or second search, and ghostly presences on the Sally Port video, and missing photographs, and the crime scene issues, and also if those wounds on that arm were created by a shattering taillight, I've got a bridge I'd like to sell you, and so forth and so on. I don't know why the state is bringing you. They do understand they don't have to bring the case, right? They understand it's optional, right?
just because you can doesn't mean you should. And, you know, I mean, you just gave a nice summary of, you know, a lot of these issues. How are you getting past all of those and establishing there isn't even a reasonable doubt? There's no plausible possibility, really. Again, just a reasonable possibility
Yeah.
that it could have been this, it could have been that on all these points. And if, again, it comes down to jury selection, if they follow the law and they follow the evidence, then it appears compelling. And of course, you know, did you brainwash and get rid of the kooks? In this case, no, they didn't get the chance to.
Yeah, I mean, and that moral certainty instruction is usually considered to be a pretty strong instruction in by comparison. It's
I,
like,
you
I
know,
have to believe this to a moral certainty. It's like,
it's
I don't know about that, man.
it must be from the old puritanical days of
I believe it. Yeah.
Massachusetts, because we sure as hell don't have that in New York. I mean, I remember, again, when you were a prosecutor and you're listening to the jury charge at the end, and the judge is instructing the New York jury on what reasonable doubt is. And I mean, one of the running jokes in the DA's office was, how the hell does anyone ever get convicted of anything when a judge is defining what reasonable doubt is in this state? I mean, it was just, I mean, there were some judges who would say, I'm not even going to say, that you must convict, you should, some judges would even give a really
Right. No, I've definitely seen that in jury instructions where it's like, if you don't find this, you must
thing.
acquit. But
Yeah.
if you do find it, you should convict. I was like,
Uh,
I've definitely seen that before too. It's like, holy shit, man.
it's
So I was like,
different.
I don't even have to. So technically,
I
it's not even jury nullification. Technically, I'm following the instructions by not convicting. That's great.
Exactly. So, but the Massachusetts instruction is really strong. I mean, you're asking people to say, to a degree of moral certainty. I mean, that's tough.
That is truly amazing. Yeah, I mean, it's and then of course you just have to feel for Karen on every possible level. This has just been amazingly difficult for her. She's never really been given a proper opportunity to grieve over the whole thing on any level, and the attorneys over here are doing yeoman's work at this point. Surely they're doing it for free because they're can't they must have blown through any possible money long ago with the amount of attorneys that are there and how many hours they've put in. It's like, holy shit. So
Yep.
I mean, these attorneys are doing yeoman's work, and the whole thing is incredibly frustrating on a whole lot of levels. And then of course you have the judge with her rulings, and you want to tear your heart out or your hair out. It's like I still have I still have the ideal, right? I still have the ideal of justice, pure and true, and it's
No.
attacking my conceptions. It's making me sad inside. Next thing
Yeah.
you'll tell me there's no Santa Claus.
Yeah, this case is pretty gross. I mean, just again, and it's funny because a lot of the people that get so angry and they get so triggered because we believe that she did it. Okay, not only do you still have to answer the reasonable doubt question, which you can think someone did it, but recognize the case stinks, which it does. That's just the reality. The case itself stinks, but a lot of that anger is mischanneled. If you honestly believe that a terrible crime was committed by the defendant in this case, whether it's as bad as murder or whether it's as some form of involuntary manslaughter, drunk driving type of hybrid, the blame here should go with the Norfolk DA, the Massachusetts State Police, and the Canton Police Department, who basically, at least the police agencies in this case, didn't give a shit about a deceased police officer they found on the lawn of another police officer because there's no other conclusion you can reach because they didn't make any serious effort to do this the right way. It wasn't an all hands on deck kind of case, which it always is when there's a death of a police officer.
Yeah.
They just did so many weird things. There were certain things they didn't do, and they screwed up clearly. Whether the defendant is guilty or not, they screwed up, and a lot of that anger should be channeled towards that because this is one of those cases that it's certainly something I've never seen. There are always cases where you can say, well, the cops did a terrible job, and they screwed up the evidence, they did something, and that factors in. One thing I've never seen is a case where, in the span of about 12 to 72 hours, two separate police agencies totally screwed this up. Not one, two. The Canton police screwed the pooch from securing the crime scene initially and, in their attempts to kind of react to this. And then the state police completely destroyed this over the course of the next several days. And, as lawyers and people, you just say, who's ever seen that? I've never seen that. And I mean, I do exclusively criminal work, and I've never seen on either side of the table where two separate agencies could do such an atrocious and pathetic job in a murder case, of a well-respected and highly regarded police officer. It's pathetic.
Yeah, I've read like Hardy Boys and Encyclopedia Brown and stuff, and I feel like I could give it a half of a go.
Encyclopedia Brown. Wow. Bugs Meany, right? Wasn't that
Yeah,
the?
yeah. We'll
Yeah,
do some hardcore.
I used to love those. Wow.
Someone asked me to ask you what you think of quote unquote Krusty getting a payout from the Commonwealth. They said you'd understand. Do you know what
Uh,
a Krusty is?
I know what they're talking about. That's something I can't get into that stuff.
Fair enough. Yeah, that's fine. I did enjoy talking to Turtle Boy recently on stream. It was a very interesting interview. Incidentally, I really enjoyed getting to know him a little bit. And where exactly is that in the procedural posture at this point?
Well, there's many. There are so many open cases at this point. The vast majority of them are pending decision on a motion to dismiss, which has been in the hands of the court now for almost 2 months. So we're working on that. There are other charges involving, an ex-girlfriend, or I'm not sure if that's even the right word, but that, are going to be dealt with separately. But, those are very strong defense cases. There's a more recent case involving allegations of witness intimidation by looking into a camera. And
yeah, I noticed. Yeah, that was a good one. He told me about that. That was pretty interesting.
So, yeah, I mean, what do you even say? That's probably all of them. But yeah, there's a lot of parts. The big case involving the witnesses who are, or potential witnesses, because Brennan's not calling most of them, against him are those are pending motion to dismiss. Ironically, by the way, in that case, I'm not going to talk about the merits of the case, but two of the named victims in that case who allegedly were caused emotional harm and intimidated in that case are named Michael Proctor and Yuri Buchanan.
I would think that those people in particular would have big boy pants, given their role, and would be a little bit less easy to emotionally wound.
Again, I'm not going to comment on it other than to say they are named victims in a witness intimidation case for, allegations of him saying things to them.
I'll comment on it. It sounds like to me that both those people being a trooper saying that they were wounded by this sounds to me like the troopers up there are a bunch of pussies. That's my opinion for the day. Eat me. I can say things like that, though.
I know.
At least because I'm not in the state. So they're probably not going to come down to Texas to get me.
I don't think so.
Yeah.
You never know.
Yeah, that's good times. Yeah, and I guess I don't know if there's really anything else in particular you want to talk about, but people are enjoying the chat. So if there's anything else in particular, I guess I'll read super chats and see if there's anything else that people want to talk about. And let's see what there was in the super chat realm. Creed M said, "Did you see Jay Petiro say Jesus is on Hank's side?" I did not. Jay Coop said, "What would you suggest defense do about Friday's hearing for the rebuttal to the Commonwealth? The new motion put it on the record?" I don't know. What do you think?
So if we're talking about, again, this aperture, moving the goalposts, this is a mess. And this is why I would move for a mistrial. And I'd make a long record. I don't expect her to grant it because I don't expect her to grant it. But I would make the record, and I think the issue becomes this. You can't allow, this new report or new information. You can't have trial by ambush. It's sandbagging. They've already examined witnesses on this prior theory that was represented to them, would be the evidence in the case. You can't, recalling these witnesses is not, that's not a remedy. I know the judge offered it. Offering a robust cross-examination, that's not a remedy.
Robust, as opposed to what?
Yeah, Your Honor, respectfully, I can do a robust cross-examination anytime I like. Thank you for the privilege to do it this time, whether it's wise or not. So I don't think any of that is a remedy, but here's the real problem. At the same time, you can't just eliminate the report, because then Brennan is going to get up and say, but that's their opinion. And if you make them stick to their old opinion, they could be perjuring themselves, or they could be. Yeah. So we have a problem here. We have a real problem. And the bottom line is this shit should have been done before the trial started. And when Brennan says we're allowed to investigate our case throughout, fine, good luck to you. But I think the kind of thing that he said that he thinks helps him having clean hands makes him look much worse, because he said the defense has always known there's been a variance. This has always been an issue. And he's basically saying, I can do this anytime I want because there was a variance. It just turns out to be that, after Whiffen and the defense clearly caught on to the timeline problem, now we're going to fix the variance and we're going to move it 30 seconds here. He also said when this first came up that he was surprised by this.
Yep.
Nobody,
Right. Sure.
nobody who does this for a living believes that. Nobody.
Nope.
Experts work on their own without talking to the hiring attorney, and they would never just start preparing reports and doing work without telling a prosecutor. Experts don't go rogue, is the point. They seek guidance, and they will say, do you want it in a report? How do you want me to handle this? So to me, the proper remedy is a mistrial. And then some people say, well, they don't want to do it again. No, neither do I. This is a mistrial caused by the prosecution. It's their fault. The only reason the defense would be seeking a mistrial is because the prosecution's conduct is gross. It's sandbagging. They've known about it. It's intentional. And therefore, there's no manifest necessity, ergo, ipso facto, there shouldn't be a retrial, because that would violate this time double jeopardy, and it really would, even though no one in Massachusetts thinks anything else violates double jeopardy. So if it were me, I would show up and make a lengthy record, demand a mistrial. If she denies it, it's all preserved, it's all there, and you're creating a roadmap. If you come in second place, which they don't want to come in, obviously, but if they do, that mistrial application is a perfect roadmap for an appellate court to say, yeah, this is a violation of due process. So look, great lawyers can disagree, and they're great lawyers. I thought they came in a little soft the other day in just saying we need 4 days. Yeah, okay. No, I don't want 4 days, Your Honor. Case is over, okay? We started trial on this, and they sandbagged us, and they did it intentionally. And if nothing else, then we need to have a hearing. Because why did this guy say, I need to sync my data to Whiffen? That's an incredible admission. Why did Brennan say he was surprised? Why did, he made this big stink about all the ARCA stuff, but he dumps this report and says, I can do this. I'm allowed to do this. To me, I think you have to come in hot and make the record, let her do whatever she's going to do, preserve it. And don't tell me that a robust cross-examination is enough. I don't want to recall Guarino. I don't want to recall Jen McCabe. The jury may look at me and say, what's wrong with you? Why are you doing that? Why would you forget the first time? No, this should have been done before trial. And they've had their expert for all this time. And why did he change the data now, right after Whiffen testified? That makes no sense to me.
No, you got to massage that evidence to be what you want it to be.
And
that's how you run a prosecution, right?
At a minimum, since this court really likes to do dauber hearings when they're in the other direction. If he changed his opinion, I want to know, did he change his methodology? What happened? Why can't we determine that outside the presence of the jury? Now, if he claims his methodology is the same, and his argument is, Your Honor, I'm just not that bright. I made a mistake, and this is my pinky promise good opinion. Okay, well, that's not going to be so good for the prosecution. But, I think the court ought to be taking evidence. How the hell is this happening mid-trial? And I'd also want to know, where are the communications that, remember the famous ARCA communications? I need to know that the prosecution wasn't involved in this, because I think they were. They had to be. And if they were.
I think so.
So if they did things that were designed to create this, well, that's intentional misconduct.
Yeah.
So I don't like what the judge is doing, but I thought that the defense should have come in a lot hotter on this. And it's not about starting over. Nobody wants to start. God, nobody wants to start over with this thing. The argument is they forfeited their right, meaning the prosecution, to do it again because this mistrial was caused by their intentional misconduct.
Yeah, kind of like Alec Baldwin sort of idea.
Similar, yeah,
Yeah.
yeah,
Compare.
yeah.
And not only do they like Dober hearings, apparently that they like voir dires. I have never, I don't believe, ever seen a voir dire of a fact witness in the middle of their testimony. I think that's a first. Have you ever seen that?
Of course not. No, and
Yeah, no, I didn't know that was a thing. I didn't know that was an option.
we had a voir dire of a police officer
Uh-huh.
because the DA in the middle of cross examination made an ouch objection because he's getting clobbered, and now I want to object because I think it's going to be hearsay. When of course none of the stuff that he was being asked about is hearsay. I mean, it's not being offered for the truth. It's trying to, were you aware of these things? It's trying to show, what did you do? I mean,
Right.
that's
I mean, that sounds right to me. Were you aware of it? So that, yeah. Did you know that?
yeah.
Yeah.
So
What's the problem again? I don't know.
there was no problem, and that was ridiculous.
Yeah, I like the judge has been objecting or allowing or sustaining objections to a lot of those things. Like, did you hear this or were you aware of this? It's like, isn't that because what you did or did not do responsive to it in the investigation? It's like, did you hear about that? And if
Not
so,
only that,
what did you do?
Buchanan testified, we're all responsible, and Proctor's not the lead. I'm as much the lead as he is because none of us did 50% plus one, whatever the hell that was. So if Buchanan was supervising the case manager and was involved at all steps of the investigation, that he's a competent witness to be grilled on, well, were you aware of this in the investigation? And if you were, what did you do to, look into this or look into that? That's not hearsay.
That's applying too much logic to the situation, Mark.
It's not hearsay. It may be many things, but it's not hearsay.
No, I absolutely agree. The voir dire, I actually put on screen like voir dire hearing, what the fuck, question, because I'm like, I don't even know what we're doing right now. This is, people come to me for intelligent commentary, and I'm like, I have no idea what we're doing. This makes no sense to me.
The only voir dire that I'm familiar with in the middle of trial, and I spoke about this, I think with Melanie Little last week when we were chatting for a little bit. Awesome. Certainly in New York, when the prosecution tries to offer evidence, before you just say no objection, you're given the right to voir dire. And I don't know if that's the thing in Massachusetts or the defense is just not doing it. But like, for example, when they kept introducing all these taillight pieces that Buchanan was testifying about that he didn't recover, and he's saying, these are them, these were found here. I would, every time, Your Honor, brief voir dire, Sergeant Buchanan, these pieces that we're talking about, you didn't find these, just right. This was, so you're relying on what you were told and you don't know where they came from, And they say, all right, no objection. But I would just put it in front of the jury that this is a joke and this guy doesn't know anything. Maybe that's not a thing in Massachusetts. I don't know.
Very good. Let's see if there was anything else here in the chats. Let's see. $20 from Quintessence, who said, so great to hear one of the most brilliant legal minds with a YouTube channel craft intelligent and interesting questions / comments for the brilliant and beloved Mr. Bederow. That was very nice of both of us. 100 euro from Pro Gamer. World is watching and seeing the vast web of corruption and abuse of power in Massachusetts. Yep. My Mayflower, my Irish, and my Rhode Island Regiment Revolutionary ancestors are buried in Norfolk County. I have not been as surprised if it was the Deep South. Yeah, there's some uncomfortable truths about that somewhere. My bias, my bad. Thanks, Kurt and Mark. $5 from MLE. Officer John O'Keefe was abandoned by his brothers in blue. When he needed them the most, they turned their backs and chose to look the other way. Facts. Let's see. $4.99 from J Coop. How would you handle the fact she's letting the Commonwealth have rebuttal after ARCA? Well, I mean, that was always going to happen. They were always going to have the rebuttal case. So the fact the Commonwealth is going to have a rebuttal case after the defense was always going to happen. So
yeah, rebuttals
are rebuttal. $5 from Josh H says the Commonwealth timeline is a mess. The 30-second shift actually helps Karen Reed. She now has less time to make it back to John O'Keefe's to connect to the Wi-Fi. Someone asked about the FBI investigation or DOJ. I don't really know anything. I think it's quite possible that due to any number of situations, also because there's a new administration since January, there's a new U.S. attorney. who has different priorities. And so I think it's quite possible that the DOJ just is not as interested in this anymore. But I don't know if you have any particular insights beyond that, Mark.
No, I mean, people have always asked, what are they doing or what are they not doing? And the answer is, I have no idea. They don't really tell anyone. I mean, there was some discussion several weeks ago. Oh, Helena Rafferty told everyone it's over. And, then she resigned like 2 weeks later. Now, that may not be related. I don't, know what that means. But I have no idea what the feds are doing or not doing. So I wouldn't even begin to speculate.
Okay, fine. All right, cool. All right. Well, I guess that will end the stream for now then. I just would like to thank you again so much for your time.
This is
Can
fun.
you tell us where people can find you, social media, where they can look you up, so forth and
Yeah.
so on?
Twitter is my last name, Law, Bederow Law. Easy to find Twitter. I'm usually pretty loud out there.
All right, cool. Well, thank you very much, sir. And if you have want to come back on at any time to talk about the Turtle Boy case specifically or other things relating to that, then that's fine. And I'll be happy to talk about that as well if you like. So it's totally up to you. Yeah, when it's over. When it's over someday in the future.
Say 2029.
Thank you very much for coming, sir.
Thank you. Have a good one.
All right, bye-bye. All right, my friends. Well, thank you very much to Mark Bederow. That was a very insightful conversation, and I very much enjoyed our discussion. I enjoyed his insight and perspective, and I enjoyed what he had to say. And I enjoyed very much his thoughts about the weaknesses of the state's case, which I share. And then I guess the only dispute, so much as there is one, is how much do we think that matters in the calculation relating to what the jury will or will not do. So we sort of all agree as to the elements of this picture, although there are some disputes even then, to be honest. For example, he is much more critical, as I think he has a very strong right to be, incidentally. I think it's a very valid opinion that, the droniness and monotoneness of Brennan is much more of a liability than I initially gave it credit for in my assessment. So I might have been too generous to Brennan, and perhaps not as generous as to AJ with respect to the opening. And it's like, yeah, I think that's a fair critique. And then, of course, with respect to the weaknesses in the evidence, I mean, all those things are very, very true. The evidence is problematic at best. The witnesses who say I hit him, like none of them said it, that night. None of them said it earlier. It's in no reports. It's not captured on any video. No one said it in their grand jury testimony. The police didn't arrest anyone or anything else, so forth and so on. So that was, of course, a whole thing. We both agree the defense should call Proctor 100%. We both agree that there's basically no way that can go wrong. Every answer is equally good. All the answers are equally good. So yeah, call Proctor and have a lot of fun with that. That should be fun. As to whether or not you should call Higgins, I don't know. I think there's a case to be made for it. I don't know if you necessarily can get as far with calling Higgins as the defense, but it's not necessarily an inherently bad idea. I don't know if you get as far or get as much from calling Higgins directly, but maybe it's worth it. So I think that's a perfectly valid opinion. And then, of course, how it all plays out in the end to the jury, who can say? But I share his wish that in the end, the jury will rule on this based on the evidentiary picture. And I will remind the jury, as I'm sure the defense, as I'm sure the judge will themselves remind the jury, your task here is really clear at the end of the day. This is not a who done it. This is not a who's most likely. This is not even did Karen Reed did it. That is not the question. The question here is much more precise and much more exacting. The question is exactly, has the state proven the charge as to each and every element of the charge beyond a reasonable doubt? That is the question. Not did Karen Reed did it. Not even was she framed. Did she hate John O'Keefe? It's really like boil this down simple at the end of the day. Can the state prove it beyond a reasonable doubt as to each and every element? And if she didn't hit him with the car, that kind of destroys every single charge because that's kind of necessary. So yeah, it's like, well, I'm back to where I started, right? As I try to find the easiest way to resolve this, look for how water can find the cracks in this pavement, right? Where is the lowest point for this to resolve? How can I make my life as simple as possible? Like the easiest way for me to make this resolve is that I simply do not believe it is plausible, let alone sufficiently plausible, for the purpose of beyond a reasonable doubt, that Karen Reed can hit John O'Keefe with a 7,000-pound car going 25 miles an hour in reverse, which by itself, by the way, is one hell of a thing. Anyone who's tried to drive in reverse knows that that's challenging at best. And try to do it at 25 miles an hour at night at 2 in the morning when you're drunk and all that. I don't know, man. I don't know. But putting aside all that, I don't think it's possible that she can, in fact, drive a 7,000-pound vehicle, hit him, somehow create some kind of disabling injury, whatever that would be, but simultaneously not create any broken bones, torn ligaments, or even bruising. I just don't think that's possible. And even assuming it's possible in a medical sense, I don't think it's sufficiently plausible to get me to beyond a reasonable doubt. Like the actus reus, the action, is, of course, an essential element of the crime, that the act occurred. She has to have hit him with the car. And also, of course, causality. That also, not only does she have to hit him, but the hitting him has to, in some sense, killed him, even if indirectly, right? If, he was disabled by the car and succumbed to hypothermia, that would be fine, right? Because it would be the causal chain. The car caused him to die of the hypothermia, therefore she's responsible. Yeah, it's like that's fine. But you still need to have the act and you need to have the cause. So first of all, I'm not sure she hit him at all. And second of all, even if she did, how is it possible to create an injury that's disabling but not bruising that led to death? And I'm just not buying it. I'm not buying it. And then of course, on top of all that, even if somehow you got me past that issue, if somehow you convinced me that was plausible, we would then move on to the next lowest thing, right? So it's like, yeah, we would then move on to what the next lowest point to resolve it is at that point, which, I'm not sure what the next lowest point is. Take your picture on that one. Is it evidence floating around in someone's trunk for a month? Is it the lack of evidence logs? We don't know who we gave evidence to or where we got it from. Is it the crime lab testing one of the solo cups? We don't know which one. And then also not really testing it, incidentally. Is it the lack of reporting? Is it the fact that, everyone says, I hit him, but no one said it initially. It's in no one's report. It's under no video. Jen McCabe doesn't say it under oath at the grand jury. Is it the deleted search? Is it the fact that she is absolutely the devil incarnate? Jen McCabe, is it that? Is it Trooper Proctor with his problems? Is it the fact that they didn't try to even look in the house or search it at all? Is it the fact that they weren't able to find any plastic pieces on the lawn during the first or second search? Is it the snow blowers? Is it the rakes? Is it the shovels? What is the next lowest point of the stupid after the car hit him? What is the next easiest way to resolve it? I'm not sure what the next easiest way to resolve it after that is, but yeah. So it's like convincing me. It's like I don't. Yeah, I don't know that you're going to be able to convince me. That's a lot, But what the jury will believe, of course, is on a whole nother thing. And so I still am afraid, even after talking to Mark, and I appreciate that he assesses the probabilities differently, and he has way more experience as a trial lawyer, so I'll give him that for sure. So his assessment may be better than my assessment, but I'm still concerned that the jury may latch on to the confession admission because they heard it from 4 or 5 people. And, well, they can't all be lying now, can they? And admissions, confessions, unfortunately, get you a long way. And if the physics, medical evidence that they're going to bring into their later case / rebuttal case, if their medical physical evidence is really good, or at least sounds really good, if it sounds persuasive, I still think that there's a uncomfortably high chance of a conviction here compared to the first case. I think Brennan has laid out the witnesses in a strategically perfect order so far. On direct, he's been great. On redirect, not as much. I tend to agree with Mark on redirect that Brennan has not been as good. Although I don't necessarily agree it's been as disastrous as Bederow would say, as Mark Bederow said. I don't necessarily agree it's been as disastrous, but I would agree that it hasn't been doing him a lot of good. I'd agree with that. Um, and Brennan, of course, comes off as a weasel, snake oil salesman, and all the rest of it. And so there's all those things. So, you know, all that stuff. So, you know, and of course, you factor into the equation the 5 to 10% base chance they convict just because there's a defendant sitting there. If not guilty, why guilty shaped? You factor in that it's a cop who's dead, and the jury is going to be like, well, we can't let this crime go unsolved. We've got to do something. We've got to do something. So I think those factors are very, very real. And how that plays out in the percentages, is 60% to convict of something too high an estimate? It might be. It might be too high an estimate. But I don't know that it's like insanely wrong. Or else obviously I'd change it. I mean, if you wanted to argue with me and said, I think it's only 40%, I'd be like, I guess. But, at that point, I'm not 100% sure what we're arguing over. If it's 40 or 60%, it's like, okay, you say 40, I say 60, we'll call it a day, But I think that, with a little bit of skill, which unfortunately I think that Brennan has skill. I think with a little bit of skill and you know, a little bit of magic, a little bit of leaning on the dead victim, a little bit of this, a little bit of that. I'm very concerned about this case. I continue to be concerned about this case in front of the jury, and so I just try to assess it. Sorry to be a bit of a downer, I don't believe it, but I don't know that juries at the end of the day necessarily apply that with what they're supposed to do. I mean, juries are supposed to review the facts and find proof beyond a reasonable doubt and all that stuff. But I think to a lot of jurors, I think vibes and zeitgeist and overall impressions and um, you know those factors can be non-trivial. So I remain significantly concerned that we are heading towards a conviction. Of course, some of that probability is based off of my basically, in order to get to 60%, I'm assuming the best possible case for witnesses we haven't heard from. So that is the best way to criticize me, is because my assessment of a 60% probability is best based off of, in no small part, witnesses we haven't heard from, such as Aperture, such as the dog bite person, such as whatever new medical person they're going to bring into this equation. I'm just assuming those witnesses are going to be good for them because obviously, they wouldn't call them if they weren't. So I'm assuming that they're going to have, some great people that are going to come in and tell the jury all the things with a little bit of, scientific sounding jargon. So it's an assessment based off witnesses we haven't heard. But yeah. Also, of course, another way of criticizing me is by pointing out that this whole Michael Proctor thing could blow up in their face a lot more than I'm anticipating. I mean, Michael Proctor was already a walking trash fire the first time around. And now we have the additional fact that he's thrown off the force, dishonorably discharged. That's gotta burn. So, how much do you factor that into the equation? But of course, you should only factor in the difference between Michael Proctor version 1 and Michael Proctor version 2, right? Michael Proctor version 1 already testified. So his liability is relating to him just being a scumbag in the text messages and the investigation. Like, those are already known quantities. So you can't really factor that. You sort of have to just take that as a given because that was true the first time. What isn't true the first time is, of course, him being dishonorably discharged. So how much more does that screw them over? Also, how much does it screw them over that the defense is the one calling them over as opposed to the Commonwealth throwing the sting? How much does that screw them over? I dropped it from two thirds to 3 over 5 from 66 to 60%. It's like, oh, that's worth a 6% drop just by the fact that the defense is going to call him, and that's going to be ugly, and they're going to make it painful. And that seems like a strategic mistake. But, I mean, you could assess all these things differently. I suppose that's an interesting question for the chat. Not trying to divorce yourself from what you personally think. What do you think is the probability? And you can use, obviously, everything you know from trial one, because everything you know from trial one is obviously still in play. So, what do you think is the probability if you had to, and, you also have to make some sort of guess here about witnesses you haven't heard from. But what do you think is the probability that, that the prosecution can get a conviction out of this case when you sort of understand, how dynamics work in the real world versus the pure world? What is your probability assessment of this thing? I certainly hope it's not true. I certainly hope I'm wrong. That would be nice. I don't want to be right. I'd really like this jury to, say that this is some absolute bullshit and call it a day. But juries don't always behave that way. So, all those things. Let's see what you guys in chat are saying. 50%, 70%, and 0. Well, it can't be 0. I mean, you think there's a 0% chance of conviction? I mean, come on, man. 40% chance not guilty, 5% guilty. Less than 5%, no way, 12% vote not guilty. 80%, 20%, 0. 50%, 70%, too much fuckery. 40%, 10%. I don't think you can go lower than 10%. I think there's a 10% chance just because she's sitting at the defense table. I think 10% is basically your baseline. But, maybe that's me. 80-20 compromise verdict. Yeah, I think that's very plausible. Compromise verdict on count 2. 75%, 50%, 40%, 10%, 50%, 10%, 80%, 80%. All they need is one person not to agree. That's very true. That's a fair point. But group dynamics are what they are. But yeah, all they need is one person to have, compunction and be a holdout and, not succumb to peer pressure and all that. That is a fair point. But I don't know how far that gets you, but it is worth noting. I don't think I'm taking into account the full need for all 12 to agree. Yeah, I kind of am, though. I kind of am. But, 10%, 20%, 68% not guilty, because you heard it's a younger jury. 90% guilty, 90% not guilty. Okay, you guys are kind of all over the map. We'll do a poll, I guess. Well, actually, one of my mods can create a poll while I'm reading the super chat, so save me some time. That's one of the reasons I have mods, right? For stuff like that. Let's read some other super chats that came in along the way. Melissa Smock has gifted a gift membership. Let's see. My cat's named Karen gifted 20 gift memberships. Thank you very much. Kaylee C. Paralegal gifted 5 gift memberships. Kat Randall sent 5 gift memberships. Thank you. AJ Red Sox sent 10 memberships. DSN has been a member for 23 months. DSN has sent 5 gift memberships. AJ Red Sox sent 10 uncivil law memberships. Kat Randall gifted 5 memberships. AJ Red Sox sent 10 memberships. Miss Lurker Extraordinaire has been a member for 1 month. Mrs. Bernsey became an uncivilian. Thank you. Darth Mack has been a member for 17 months. Rights On became a member, or has been a member for 1 month. 1 month. Thank you. I Shot the Clerk. Thank you very much for giving a $5 super chat. Vascar became an uncivilian. Jules asked, could the defense bring in Chloe if she's alive? I don't know. KFG, $5 said, no way. They have such a corrupt trial without also corrupting the jury. Fair enough, man. Fair enough as to all those things. Well, I'll tell you one thing you can do to help me out, by the way, personally, as long as there's 5,000 of you here. What you could do to help me out would be to retweet the pinned link for Monday. So I'll go ahead and just spam that in chat and then pin it. If you wouldn't mind hitting, loading that up in your Twitter and retweeting that for Monday's stream, it would help me a lot. And then at the end of the stream, I'm going to dump you over into the stream for Monday. And if you'd hit the like button, that would help too. But it would help a lot with discovery if all those people, if the people out here that have the Twitter, if you would be so kind as to please hit that pinned comment and hit that retweet, just write, a little comment, free Karen Reed or Karen Reed rules or whatever. If you could pin that, if you could retweet that, it would really, really help with discovery and, promotion of the channel. And I'd really, really appreciate it. Thank you. We do merch giveaways, by the way, if we get enough likes during streams. So on Monday stream, for example, if we hit 550 likes before the lunch break, then we'll do a merch giveaway. So if you tune in, you might be able to win some merch for free. And that's fun. So, you can tune in for that. That's exciting. You wonder why the defense doesn't talk about the no collision report? Well, it's not their turn to talk about things yet, but yeah. Only if I promise to stop harping on Jackson? No. I make no such promises. I cover content as I see it. I give you my best opinion. You may or may not like my opinion, but I'll always give it to you the way I see it. So yeah, no, I'm gonna give you my opinion. Now, to be fair, recently of Jackson, I thought that Jackson's style has been more appropriate for the witnesses he's been cross-examining recently, because I thought there was a lot more juice there. Mark Bederow didn't think it was a problem with the early witnesses, which, okay, fair enough, I suppose. I thought it was a problem, but I don't think it's as much a problem with these later witnesses because there's a lot more juice to get out of the squeeze. So I didn't think he came off the same way because I thought there was more there to work from. But yeah, no, I'm not going to change my opinion. I'll give you the best opinion I can. My opinion may change based on what happens in the courtroom, as it does. But, if I think Jackson is making a mistake, I'm going to tell you. For that matter, if I think any of the lawyers are making a mistake, I'm going to tell you. If I think, Brennan's making a mistake or Alessi's making a mistake or Yannetti's making a mistake or anybody's making a mistake. Oh, yes. Also, there's a poll active as well. So make sure to, do that. Brennan tried to impeach his own witness. He did a little bit. That was pretty hilarious. Most appealable issue for the defense? What is the most appealable issue as we sit right now for the defense? Possibly like the report that changed, unfair notice, unfair surprise could be a thing. But and the fact that the judge didn't give them anything to work with, bias probably would be pretty big. It's hard to prove, but I think there's a lot of evidence to support it. So bias is a pretty strong idea. What else would be really good right now? She hasn't limited our aperture ARCA in any way. So there's nothing there. She hasn't taken any actions against the defense. So in terms of limiting them, so there's nothing there. So yeah, bias is probably the best issue for an eventual appeal. The admissibility of some of the experts. For example, the dog bite expert, I think, could be challenged as not meeting minimum standards. I think that's a possible ground of appeal. That's what's going on. Bederow not joining? No, that doesn't really get you anywhere. That doesn't really get you anywhere as an appeal option. Excluding Easter? Yeah, the defense is probably making a mistake when they compromised relating to that, but the judge didn't give them anything. If the judge had actually given them what they wanted, you know, then it would have mooted the issue, but she didn't even do that. So, yeah. Not admitting Michael Easter for police procedures. Yeah, that could work. I can see that as a ground of appeal. Yeah. Bringing in new evidence in mid-trial. Yeah, unfair surprise stuff there. There's some options there. Yeah. Late new evidence is a pretty big deal. Can be. Yeah. The question there, of course, would be like the question there would be the degree to which it prejudiced the defense in their case from before they were aware of it. So the degree to which it really impacted their case or impacted their presentation of the evidence before they were aware of it. Because obviously the defense case hasn't started and it's not going to start for any time in the foreseeable future. It seems like so arguably they have time to adapt to it for their case, but to the extent that they've been asking questions or predicated on, you know, bad evidence, then that's a potential problem. Although if the judge gives them the option to recall the witnesses, that arguably cures the error, even if they don't take advantage of it. So if the judge gives them ability to recall the witnesses, then that probably is sufficient cure from an appellate posture. Appeals are hard. She would be in jail during any appeal. Yes. Yeah, she would be sentenced and serving time in any appeal. And of course, appeals are for losers. Appeals are hard. You know, not only do you have to find a mistake, but you have to find a mistake that matters, which is problematic. You have to find because you run into a harmless error analysis pretty easily. It's like, yeah, this was a mistake, but it didn't really matter because it didn't influence the verdict. So you not only have to find a mistake, but you have to find one that made a material difference and created some sort of prejudice that requires a remedy. That's challenging. Appeals can take forever as well. Yeah. Let us take a look at the poll in chat. All right. So of the 900, let's go ahead and end the poll. Of the 961 of you who voted, how likely are they to convict Karen Read? 1 to 40%, 82%. 40 to 80 said 14%. 80 to 100% said 2%. So you guys believe there's a less than 40% chance to convict. I hope you're right. I hope I'm being overly jaded. I hope I'm being overly jaded. Could Karen Read go after the Commonwealth for malicious prosecution? Not really, no. Although she might have a cause of action hypothetically against Proctor, maybe. But probably not. Probably not the prosecution team. No, but they might be able to get the Proctor for some civil rights violations relating to searching the phone. Yeah, they might be able to get to a violation by Proctor. She might be able to sue Proctor, maybe. 1983 claims are also hard, but there's a possibility there. Also, potentially, like, because the supervisors like Buchanan and stuff were aware of it and didn't take steps to correct it, you might even be able to get to some sort of pattern in practice, hypothetically, that you could sue the supervisors and the police department potentially for something on a 1983. But 1983 claims are hard because not only do you have to show the violation, but you have to show the violation was clearly established, which unfortunately in the law requires a very, very, very close analog. You basically have to find the exact same cases happened before. And that's harder than you might anticipate. So 1983 claims can be incredibly difficult. 1983, by the way, is 42 USC 1983. It's the cause of action that you sue the police or prosecutors for deprivation of civil rights. So it's a 1983 claim because it's Section 1983 of Title 42. But they're very tricky to bring. Qualified immunity, yep, that goes a long way. Also, it's the state police, right? So you have a sovereign immunity problem on top of everything else. Yeah. So your ability, you probably can't sue the Massachusetts State Police because you have a sovereign immunity problem. That sucks. Is there no fruit of the poisonous tree rule in Massachusetts? There is, but it's more complicated than that. There are ways around that problem. What are the odds of a hung jury? I don't know. What's the probability of a hung jury? I don't know. I suppose by necessity, it would be a hung jury or acquittal would be anything that's not a conviction. So the probability of a hung jury / acquittal would necessarily be the exact inverse of the numbers you just gave. So there's that. Oh yeah. Also, we do a lot of Supreme Court analysis over here. I hope you like that kind of thing. We do Supreme Court cases. They're a lot of fun. Some good stuff happening at the Supreme Court this term. Some very controversial stuff, especially relating to immigration. Lots of interesting stuff happening right now. Cars and phones seized without a warrant. Yeah. Inevitable discovery will get you a long way on that issue. It's like we could have gotten a warrant, so inevitable. Yeah. Ask ChatGPT about Karen Reed. Ask it what about Karen Reed? I don't understand. What do you want me to ask? Just ask in general. What do you think about Karen Reed? Yeah, the birthright citizenship case is very interesting, although that's not really what they're discussing right now, but they sort of are, but not really. What they're really discussing is universal injunctions, which is an issue that goes beyond birthright citizenship and affects every case, at least against the administration, and not just this administration, but any administration. So it affects all lawsuits basically against any executive branch agency, what the rule is relating to injunctions. So, very interesting issue. We asked ChatGPT the probability of finding guilt or not. Okay, that's fair enough. Let's ask GPT. That's fun. Let's do that. I like that. I like that idea. Let's do that. That's fun. We can ask ChatGPT what it thinks about the probabilities of various things. Let's see. Okay, I want to share with you. All right, hold on. I like this idea. We'll ask ChatGPT what it thinks. We'll have to figure out how to phrase the question, which is, the challenging part sometimes. Okay, let's see. So first of all, which ChatGPT version do we want to use? Advanced reasoning is probably the way to go, right? And we'll do for search, I guess. Let's see. How do I even phrase this question? Given what is generally understood about the dynamics of juries, and given how juries uh, assess evidence based on factual considerations versus emotional considerations. Um, what is the probability of the jury in the Karen Reed murder trial convicting versus hung jury versus acquittal? Um, use any reporting about the trial along with any sources discussing jury dynamics in the assessment. Let's give that a shot and see what that does for us. I'll say current jury just so. That started on April 1, 2025. Okay, let's give that a shot. Let's see what we can do. It's thinking. It's thinking, Prince. I can't make it think any faster. It's thinking. All right, let's see what we got. Because jurors in Commonwealth versus Karen Reed are weighing sharply conflicting forensic evidence, a powerful emotional narrative surrounding the death of a beloved Boston police officer, and a well publicized defense theory of a police cover up that already produced a hung jury in 2024, the odds of unanimity in either direction are unusually low. Synthesizing national hung jury statistics with empirical research on how complex emotional trials polarize deliberations, and factoring the specific twists and turns reported to the retrial date, I estimate approximately 40% likelihood of conviction, 40% likelihood of another hung jury, and 20% likelihood of outright acquittal. These numbers are, of course, probabilistic judgments rather than certainties, but they reflect the best integration of current reporting and jury decision science. Well, I mean, plausible. I guess that seems plausible. Methodology, baseline rates. Nationally, criminal juries deadlock about 6% of the time, with murder trials clustering closer to 11 to 15%. Class specific adjustments. I applied Bayesian updating to those baselines using 4 dimensions widely shown to sway verdicts: evidentiary strength, evidentiary complexity, emotional loading, and prior trial outcome. Empirical weightings were taken from peer reviewed stories on jury cognition and emotion. Qualitative calibration. Real time reporting from the courtroom supplies details on which piece of evidence appear to resonate or fall flat. Key evidence and emotional drivers. Pro prosecution highlights. The alleged admission. A first responder insists Reed repeated, I hit him, I hit him. Taillight fragments and DNA. State crime line analysis said taillight shards at the scene matched Reed's SUV, with O'Keefe's DNA on at least one fragment. I don't know anything about it being on a fragment that was found at the scene. I don't know anything about that. I know DNA was found like on the tail light housing, but that's not the same thing. Autopsy finding. Medical examiner testimony described blunt force injuries consistent with vehicular impact. These data points bolsters jurors' factual certainty while also invoking anger or moral outrage, emotions that tend to amplify the tendency to convict. Pro-defense highlights. Cover-up narrative. Defense alleges cover-up, corrupt policing, and mishandling of evidence. Jurors have already heard about the shredded phone data and investigators disciplined for misconduct. Facts. Alternative perpetrator. Text between Reed and ATF agent Brian Higgins hint at motives and cast suspicion on partygoers inside the home. Further facts. Forensic complexity. Conflicting evidentiary expert explanations of snowbank physics, bruise timing, and cellular location data increase cognitive load, which tends to erode confidence in any single narrative and favor deadlock or acquittal. Prior hung jury. The first trial deadlocked after 27 hours of deliberation, demonstrating that at least one juror previously found reasonable doubt in the same core record. Research shows that mistrial materially raises the probability of a second hung jury. What jury science tells us? Factor, victim status, police officer. Increases pro-prosecution motion and punitiveness, favors conviction. Yeah, I said that too. The fact that it's a police officer definitely has to change the analysis to some degree. The fact that it's a police officer dead definitely changes the analysis. Complex forensic testimony. When comprehension is low, jurors default to heuristics, often splitting along pretrial biases that lead to more deadlocks, favors a hung jury. Narratives of official misconduct. Heightened skepticism. Mock juries show acquittals when state actors seem untrustworthy, therefore favors a hung or acquittal. Defendant's demeanor and gender. Female defendants in violent crime cases receive slightly lower conviction rates. Slightly favors acquittal. Prior media saturation. Pre-trial opinions can polarize deliberations evenly divided. Hung jury is more likely. Favors the jury. So, probabilistic estimate. Verdict outcome. Conviction. 60%. Well, that's what I said. So now are you agreeing with me? Although now you're adjusting. Because that's a base rate, you're saying. Base rate for murder is 60%. Adjustments. 20% for forensic complexity, 10% for the cover-up doubt, estimated probability at 40%. I would not give as much as ChatGPT is for forensics complexity. I don't think it does as much as it's weighing that. I think it's overly estimating that factor. Hung jury, 12% base chance. 18% plus for complexity controversy, 10% relating to the prior mistrial for 40%. Acquittal, 28%. 5% for emotional pull for the victim, 3% for mission evidence, leading to a 20% acquittal. Limits and caveats. Incomplete record. Defense has not yet presented all experts. Pivotal testimony could still sway sentiment. That is very true. Demographic opacity. Without voir transcripts, the model can't weigh juror age, education, or policing attitudes, each of which measurably shift verdict odds. Maybe we could tell it about the jury and it could factor that in. Is there any reporting relating to the demographics of the jury? Is there any reliable reporting relating to that? Maybe we could tell it and it could factor that in. Small n problem. Every juror is a sample of 12. Stochastic variance means even perfect modeling can't eliminate wide confidence bands. That is very true. Takeaway. Expect prolonged deliberations. The jury must sift contradictory technical evidence while wrestling with vivid, emotionally charged themes of betrayal and institutional trust. Evidence complexity plus baggage of previous mistrial leaves the panel balanced on a knife edge, fully capable of unity, but just as likely to fracture again. I mean, okay, that makes sense. Let's see if we can find any information on the demographics of the Karen Reed jury. Let's see what we got. Jury selection makeup. See if there's anything on demographics, ages, anything. Let's see if it gives me any information from any of these websites that tell me anything about the juries. This one doesn't give me any demographics at all. This is just going through a timeline, but no demographics on the jury. It doesn't give me anything about their ages or races. I can't find any information. Nine men and 9 women in their 20s, 30s, and 40s. Okay, that doesn't really help very much, but I guess we'll tell ChatGPT that. And see what it thinks. Okay. The demographics of the jury is as follows. There are 9 men and 9 women. Their ages range between 20s and 40s. Given these demographics, reassess the probabilities you provided above. Okay, yeah, they're all from Norfolk County. That's true. All the jurors are from Norfolk County, Massachusetts. Give me these demographics. Reassess. Yeah, the fact they're all from Norfolk is not an inconsequential factor here. ChatGPT is thinking about things. ChatGPT is thinking for you and me. ChatGPT thinks about all things. By the way, have you guys clicked that pinned tweet yet and hit that retweet button? I really hope you have. I try to provide you guys value and fun and insightful commentary. Perhaps slightly black-pilled at times, but when that first jury didn't come back and just acquit immediately, it definitely shattered some of my confidence. I'm not going to lie. Thank you, Just Rhonda. Appreciated. I further clarify that 6 will be randomly. I mean, yeah, it knows that, and it doesn't really matter because, like, I mean, it's even money. The gender makeup is not evenly split in the end. Well, it could be, but you don't know, obviously. All right, the newly disclosed panel, 18 residents, split evenly, all in their 20s to 40s. Now just the outlook a bit away from guilty consensus and towards a stalemate. Drawing on empirical work that shows younger jurors are less conviction prone, mixed gender panels hang out more often, and Boston area residents retain a modestly pro-police tilt. I now peg the odds at 39% conviction, 43% hung jury, and 18% acquittal. Well, that didn't really change things very much, but I'm glad we threw that into the equation anyway. So there you go. So it just changed it ever so slightly. Have I seen Good Logic's Green Grass Theory? I have, as a matter of fact. Glad I'm following. Yeah, as well. So all that good stuff. They can't publish races? Of course they can. Anyone can observe anything. It's like it's open information. I mean, the court may not tell them, but a person can look with their own eyes and say, and see what they are. So, the court can't stop me from reporting on what I can see, you know. There was an amendment to the buffer zone order that I never covered. Let me see if I can follow it. Judge Canoni said it's prohibited. Judge Pahoni can kiss my ass. She cannot stop me. It would be prior restraint. It's literally prior restraint. She can't order me not to report something I can see with my own eyes. She can kiss my absolute ass. It's prior restraint. Fuck off. The buffer zone is back. The buffer zone never went away. It was just amended. Let's see if I can find a copy of the amended order. I love it when the news articles refer to it, but they don't actually give you a copy of the order. That's always fun. I just want a copy of the order. Just give me the order. Stupid websites. Staff chat, thank you. Where in staff chat? I'm looking right at it. It's not there. Thank you. Anyway, okay, back to searching. Thank you. Do you have page 2, Rose? That's it? Okay. Okay. All right, cool. All right, this will work. All right, so from Twitter, here's a copy of the revised buffer zone. Let's see if I can make this bigger. Yeah. Commonwealth of Massachusetts supplemental order regarding the buffer zone. The court is in receipt of the decision of the United States Court of Appeals for the First Circuit in Grant versus Trial Court. To simplify any potential First Amendment issues related to the buffer zone restrictions implemented by prior orders, this court, guided by the Court of Appeals suggestion set out on page 12 of the decision, issues the following supplemental order in regards to the buffer zone. First, for all the reasons cited in support of prior orders and based upon the parameters of the dispute, as narrowly and described in the decision, all orders of the court remain in place insofar as they apply to courthouse property. Second, prior orders remain in place as applied to pathways, including public sidewalks and roads, through which and at times trial participants enter and exit the courthouse. Third, noisy protests, including those using amplified sound, honking horns, or loud screaming and yelling, that are intended to interfere with the administration of justice are intended to influence any judge, juror, witness, or court officer in discharge of his or her duty are prohibited within the buffer zone. Fourth, the display of written or graphic materials that are intended to interfere with the administration of justice or intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited. Fifth, any person whose activity has been restricted by an officer enforcing this order may request review by a judge of the Superior Court, which request shall be heard as expeditiously as possible. Quiet off-site demonstrations of public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse and do not interfere with the orderly administration of justice and are not intended to influence any trial participant in the discharge of their duty are specifically outside the scope of the buffer zone restriction. So basically, she just amended it to what the First Circuit suggested to save the issue. So I don't know that she was necessarily required to do that, but that's what she did. So she did what the First Circuit suggested and thus moots any further concerns. So basically, you're still not allowed on the courthouse property. You're still not allowed on the sidewalks for ingress and egress, and you're not allowed any noisy demonstration if they're intended to influence anybody or interfere with the administration. So a very narrow change, but, a narrow change nonetheless. Cool. All right. Well, I think I'm going to go ahead and end the stream. Because I don't really have much more to say, although there are 4,000 of you here, and I'm hesitant to give up such a captive audience. So unless there's something more you guys want to talk about, we could talk about something else, but intended is rather ambiguous. No, it's not. It's mens rea. It's not ambiguous at all. You just got here? Well, okay. Can you explain what a leapfrog appeal is? Well, I've never heard the term before, but it would suggest that you're skipping a step because you're leaping something, presumably the Intermediate Court of Appeals. So I've never heard it called a leapfrog appeal, but that would be what it would be. It would be appealing from the district court to the Supreme Court, presumably. Talk random law stuff to us? Any thoughts on the Murdoch clerk? I wish I had a copy of the actual indictment / information and a copy of the probable cause statement. That'd be really nice. I'd like to know exactly what she's being charged with and also the probable cause for those charges. That would be helpful. But I've not seen any copies of the formal charging documents nor probable cause statement relating thereto. So I'd really like to know it, what that is formally what it is. But I don't have a copy of it, so that's sad for me. Let's talk about Bev's instructions she gave the jury the other day. Yeah, I don't know what that was about. Please don't make faces or please don't make noises. I don't know. It was suggested by Miss Shorty. It was suggested that one of the jurors was the person who said asshole, potentially talking about the judge themselves when the judge was like being a dick or something. It wasn't the judge who said asshole. It was one of the jurors who said asshole. And that would be the nature of the admonishment, I guess. Would make sense. So I don't know if that's true, but it would make sense. Any thoughts on why Bev seems to base a lot of her decisions on witnesses, where they're rebuttal or chief witnesses? She makes decisions to favor the prosecution and hurt the defense. She's biased. Unfortunately, it's not that hard. I wish it were that hard. I wish there were a more nuanced reason I could give you. I wish it made more sense legally. But I've been watching this case for quite a while at this point, and although it's not my favorite conclusion, I've come to the conclusion the judge is biased. She's doing it because she's biased. It's I can't really justify her decisions from first principles anymore. You know, I can't really justify the disparate treatment from first principles anymore. So I'm kind of left with bias as the most plausible explanation at this point. The Murdaugh arraignment was it was televised. I know the arraignment was. We saw the arraignment, but there was no formal reading of the charges during the arraignment. So we still don't know what the charges are, let alone what the probable cause for those charges are. So a juror or two was giggling when Yannetti was crossing the DNA witness, asking if she ever received evidence in a solo cup. That also makes sense. What should I do with the rest of my day today? It's 4:00 Central Time. Maybe I'll call my good friend Nate and see if he wants to just chill out or something. Oh no, I actually am gonna do some work on the channel after a break. You're gonna find some food? Excellent. Yeah, we've been doing 2.5 hours. I feel like it's break time. I tell you what, here's what we're gonna do. We're gonna end with a little bit of OnlyFans song because I feel like there's 4,000 of you here, and not all of you have enjoyed the glory that is OnlyFans song. Because Miss Shorty deserves it because it's a banger. It's an absolute banger of a song. So we're going to close with part of the OnlyFans song, and then it will redirect you to the stream for Monday. If you wouldn't mind when you get there to please hit the like button for Monday. And if you haven't hit the retweet button already, now would be a really good time. I bring you OnlyFans song from Miss Shorty because it is a banger and you need it in your life. Let's do this thing.
Yours Karen's innocent, only fan is outraged till the end.